Mr. Ahmed, A.C. Ahmed.
And the advocate appearing for the appellant supports that the
My lord, I am appearing for the respondent, Mr. Ghalib is appearing for the state. My lord, he could not come due to his illness. My lord, I am praying for not today only. Ghalib sir আছেন
Ghalib কি হয়েছে?
item 4. Yes.
I am for the appellant writ petitioner.
Mr. Ghalib is appearing, my lord. He could not come due to his illness, my lord. I am praying for not today only. Not today.
That apart, my lord, I have to add, my lord, the successful bidder. He was not party before the writ court, but for adjudication, my lord, he has to be added. That's my humble understanding of situation. Therefore, kindly give us liberty to add him and serve him, and the matter be taken up, Lord, after.
Application is what?
Well, that will delay the proceedings. Because admittedly, my lord, it appears that someone has been given the contract. He was not party in the.
Application will be filed. Serving and Mr. What is the advocate appearing for
You mentioned call the next week. So you have to apply an application for it.
Or affidavit of service be kept on it.
no, totally.
My lord, in item number 5, I'm appearing on behalf of the respondent number 1 to 18.
May it please your lordship, my lord. I'm on behalf of my lord, the appellant, my lord.
What are the two applications?
My lord,
There is a leave to appeal application, my lord. I was not arraigned as a party respondent, my lord. So, my lord, one is, my lord, a leave to appeal application, my lord. The second one is, my lord, a stay application. What happened is, my lord, on the basis.
You have
Yes, my lord, I have served, my lord. May I, my lord, have my lord's kind leave, my lord, to file the affidavit?
my lord, I'm led by Mr. Pranit Bagh in this matter, my learned senior. He's occupied in some other court. I'm praying for a short passover.
Passover not today.
My lord, may I file the affidavit of service also? My lord, we attempted to serve upon the state, but the state refused. So we have served by email, my lord. That is also there, my lord, in the affidavit of service.
He come tomorrow with that opposition, with that affidavit, and give a further notice.
GP officer একটা নোটিশ দিতে বলছে
Without order নেবেন accept করবেন না।
নোটিশ দিতে বলছে
আরে ভাই নেবে না কেন? চিঠি লিখে দেবে একটা।
it has fallen as per the desire of the honorable person.
Day after tomorrow.
Day after tomorrow.
Deputy-
May it appear, my lord, fairly at the top, my lord. This pertains to, my lord.
Yes, next.
State preferred the appeal. Well, that matter regarding the Midnapur.
Mr. Dotto was appealed.
Yes, my lord.
My lord, I am led by Mr. Advocate General, Learned. He is code number 2. My lord, kindly note this week.
Not today.
Not today.
I am grateful.
Ask him to be present tomorrow.
Tomorrow.
Ask the Advocate General to appear tomorrow. Yes, next.
Lordship, I'm for the appellant. Mr. Shomojit Das Mahapatra is appearing in this matter. He is on his legs before court.
You argue, madam. What is the problem?
Your Lordship, I do not have the instruction
What instruction you want?
to.
You seen the brief.
Yes, Your Lordship.
Then what are the applications about?
Uh, uh, Basically, Your Lordship, the mother,
Yeah.
the mother gifted her property, land, to two of his sons. Now, Your Lordship, one of the son sold the undemarcated portion to a third person. Then the other brother filed a preemption suit.
Right.
Then the brother who sold the undemarcated portion, he actually filed a writ petition, out of which order was also passed. So against that, we have filed this appeal.
You are one of the sons.
Yes, Your Lordship.
So what did the writ court say?
Your Lordship, come to page 46, Your Lordship. Lordship, I'm praying for a short pass over, Your Lordship.
You are arguing well. Yes. Why you are afraid?
Not a
Yes, which page you want us to?
Your Lordship, page 46, Annexure B.
ও বলছে কোনো হাঁটি নেই, বানানোর চেষ্টা করছে, কোনো স্বপ্ন নেই। হ্যাঁ, still that they enjoying the process, was trying to put up a hut with one wall in that. Then who are private responders threatened to stop the construction. Yes, we see.
They have to show me where this is my video.
Yeah, see, you are the writ petitioner.
Yes, Your Lordship. The appellant, sir.
So,
Your Lordship.
before the learned single judge in the writ petition, you're the petitioner, or were you one of the respondents?
We were the respondents.
For the respondent. হ্যাঁ, না ও যাতে তাই জন্য ওর এই হচ্ছে not to disturb, ও বলছে তো তার কোনো দোকান নেই।
এটাতে appellant.
সেটাই বলার চেষ্টা করছি। ও তো বলছে দোকান নেই। হ্যাঁ, দোকানটা নিয়ে এই যে it is specific content that there is no such shop in existence.
Your Lordship, the other side is also not there. Kindly keep a short passover. My senior will be
So
coming
you get
soon.
favorable order from us.
Yes, Your Lordship.
Then why you are praying for Passover? What is your name?
My name is I'm for the Shukumar Godai.
No, your name.
Upashana Banerjee, Your Lordship.
Hard Miss Banerjee granted advocate appearing for the appellants. Today, however, one appears on behalf of the private respondents. Whose presence is necessary for advocacy. To Mr. Shamulrat.
Lordship. Obliged, Your Lordship.
Come back.
Number 8, my lord. Mrs.
At 9, I am appearing on behalf of the respondent writ petitioner.
My lord, Mrs. Tanvi Alom is appearing, my lord.
The affidavit in reply to the affidavit filed by the appellant.
My lord, Mrs. Chandri Alom is appearing for the appellant, my lord. She is ill, my lord. I am praying for not this week, my lord.
Freedom fighter. Freedom fighter pension.
Freedom fighter, freedom fighter.
Right. This is with regard to the lifetime arrear of my father.
You have filed.
My father filed the writ application.
Why the appellant file an affidavit?
They filed an affidavit showing that the 198 cases has been rejected by them, wherein I have taken exception, indicating the maximum numbers of the person in whose favor they are claiming that the pension has been cancelled is dead.
So now you are filing an opposition to what?
To their application disclosing the names against whom they have cancelled.
So it is an exception to the affidavit
That-
file.
That
I have already served copy upon my learned friends. দিয়েছি রে ভাইটা
আচ্ছা
না দিয়ে বলবো না
ঠিক আছে ঠিক আছে
নারায়ণ হালদার নিয়েছি
না, না।
So why two appeals?
একটা state করেছে,
Why
একটা
two
state
appeals?
company. Two appeal,
Two
one is
appeals,
just
one is challenging the order, main order, another on behalf of the state
State.
against the
It's for the state.
award of cost.
Learned Mr. Mukherjee, Tapan Kumar Mukherjee. He is the appellant and Mrs. Alam is the opposite.
And
No,
adjournment
no.
has been paid for.
আপনি দুটোতে একটা প্রথমটা অ্যাপিলেন্ট
Appellant also respondent.
আপনি আর কেন থাকবেন ওটা একটাই আপোজের আপিল
Lordship, item number 10, I'm appearing.
I am for the respondent. Malad,
Lordship, এক মিনিট বলে নি।
করে নাও।
তারপরে
Lordship, item number 10, I am appearing on behalf of the petitioner. Your Lordship, in the most unfortunate turn of events, Your Lordship, my clients conveyed that they are not in a position to continue with the litigation. So I am praying for the leave to withdraw this.
I indicated that on last occasion appeal by nobody. They say likely to be affected and that is why they filed this appeal.
you are advocate on record.
Yes, Your Lordship.
Mr. Ford,
Yes.
Mr. Ford, learned advocate on record of the appellants.
Item 5.
not in a financial condition also to continue, and they do not even want to, as they are not in that area anymore, so they are not interested.
Well, may I assist your lordship, Ballot? Well, the fact is, well, the other appeal,
on the prayer of Mr. Paul Learned Advocate appearing for the appellants, the you are for the appellant,
And I am
for the appellant.
state.
you are for the
Not
state,
the state led by Mr. Bandyopadhyay, my lord.
and you are
I'm for the union, my lord, for the CBI.
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 And I am filing.
Appearing for the first time.
No,
No.
this was appeared before the earlier division bench of the Honorable Chief Justice, and there was an order passed on 7th April 2025,
Affidavit, my lord.
directing the police in charge of the Electronics Complex Police Station to show cause why this matter will not be referred to CBI. No,
CID.
CID. Though I am praying for reference of this matter by this Honorable Court for CBI. Upon primary satisfaction, their lordship please to direct the matter to refer to CID and kindly have a look to that
In the appeal.
in
The
the
appeal that order was
Yes,
passed.
Yes,
my lord. While hearing the stay application, my lord, order dated 7th April 2025. Kindly have a look.
And that order I have annexed in my affidavit, my lord. Order
Now
date,
you have filed a report.
the
Yes.
state has filed a report.
I filed the money report.
An exception has also been filed. Yes.
Exception to the same.
Yes, no, I filed exception, giving copies to them also. My lord, exception, my lord, they have misled the court also by today. My lord,
No, pursuant to the chief's order,
my lord.
they have filed
My lord, no, I was directed to file exception.
did you file?
Aye.
the
My
report?
lord, that copy I have submitted. Kindly have a look to that order first. Thereafter, I am submitting the facts in nutshell.
So we have annexed the order also in our affidavit.
And the factor has now been crystallized in the police report filed by them in earlier occasion, and to which I have filed the exception. And in nutshell, I am filing.
Last order, 8 December date fixed.
যে কথাটা বলেছিল সেটা বাদ দিয়ে আমরা এফিডেভিটে সবই লিখেছি, বলেছি যে কেন হয়নি সেটা জানতে চেয়েছিলাম, আমরা কি কি ভবিষ্যতে করেছি সেগুলো বলে দিয়েছি। রিটের পাতাটা বার করে আমাদের আগে একটা রিপোর্ট ছিল না, রিটার আগে রিপোর্ট, এই দুটো ঠিক আছে। আমাদের কপি দেখো ব্যাংকে তো দিয়ে দিয়েছিল ওদের রিটের রিপোর্ট। ঠিক আছে থাকো। কি পড়ছিস তো দেখছি আমি, আমার কিচ্ছু বলার নেই, সিবিআই বললে করবো না বললে করবো। তোকে বারবার বললাম যদি এটা এটিকায় যে আপনার অসুবিধা কি আছে, বলছে না স্যার আমরা করতে চাইছি, আমাদের ভুল হয়েছে, আমরা আবার নতুন করে নিশ্চয়ই করবো। সিনে আসে রিপোর্টের কপিটা ট্র্যাপিংটা পড়ছো অর্ডারটা পড়ছো Nashika. Sorry. সেগুলো আমাদেরকে দিয়ে দিই ওটা একটা পার্ট ছিল ওটা দিয়ে দিয়েছি এক্সিবিটা
Yes, tell us.
My lord, I am submitting the facts in nutshell. My lord, this is in respect of a perfunctory police investigation. My lord, 3 times FRT has been given. My lord, case is the petitioners, the number 2, got admission in the institution as IIPM, which is the a private, which is the brand of a private company. They made huge advertisement in inviting that this is the world first class B school, and will confer the BBA and MBA degree, and getting that advertisement, the petition number 2 who has got admitted in that institution by giving 18 lakhs. 18 lakhs. And thereafter, it has been after 3 years, the unit has been closed. That is at Salt Lake unit has been closed without any explanation. And thereafter, my petitioner find that this is the fake institution. The University Grant Commission has said that they have no authority to confer this type of degree. The Delhi High Court has taken cognizance in this matter. They have stated on their admission, they have stated that it is a fake university and it has not authority to confer any such BBA and MBA degrees.
So, who are the functionaries of the said university?
That IIPM.
Functionaries. It is under the Mahatma Gandhi University.
Yes, my lord, that I am telling. My lord, this is the IIPM. But 2 times 2 FRT has been given. Thereafter, before the trial court asked the police officer to say as to why, to say and to explain as to why this investigation has been carried out within the ambit of the case. That the in section in page 67, 87A of the writ petition, and it has been given in that their program briefs, to which it has been stated that they will afford BB and MBA degree in exchange of their stipulated fees is but getting that, and they have confessed that they have not done so. Thereafter, the trial court directed them, directed the same authority to
Who is this Mahatma Gandhi University?
I am telling after that afterwards, telling them to carry on further investigation and investigation in the ambit of the offense. And thereafter, they have repeatedly stated that the mark sheet is ready, and mark sheet is ready. My client is not taking the mark sheets. And before the division bench directed me to take the mark sheet first. I have taken the mark sheet. In mark sheet, they have produced that mark sheet in the police report. Their police report filed by the division bench also. So in that mark sheet, it has been shown on that the BBA degrees from the Mahatma Gandhi University of Meghalaya.
That institute is affiliated to Mahatma Gandhi University?
No, they have stated, Vice Chancellor of the Mahatma Gandhi University has stated that they have no contact with that institution. They are.
So the investigation that was conducted, in spite of these allegations, landed up in a final report. Final report was filed, so nothing was found against them.
No.
Challenging that, you came to the writ court.
Against two final reports, I have come to the writ court.
After two final reports.
After two final reports.
What?
Thereafter, the writ court directed them on their confession that the investigation has not been carried out properly. Properly.
First FRT Naraji, then again FRT.
First FRT Naraji, then again investigation started, and then again FRT. Thereafter came before the writ court. And writ court find in that the proper investigation has not been made.
Thereafter, that order has
On their admission, police officer came to the writ court.
Where is that admission?
My lord, that is in stay application.
Is that reflected in the order, last order which was passed on 7th April?
Yes.
Yes.
Show us from there, from the chief's order.
I'm coming. Paragraph 4 of the last order.
Page 4 of the
order dated 7th April 2025, passed by the Honorable Chief Justice and Division Bench. Page 4, paragraph 6.
Your writ petition was dismissed.
No.
Yes.
My writ petition was disposed of with direction that they will carry on investigation further in the ambit of the case.
By the
By the police authority, that the officer in charge, electronics complex, police station.
Oh, aggrieved thereby you have come up in a
Yes, aggrieved thereafter. After I have come before the division bench for referring the matter to CBI, because that the trial court has directed the same authority. That trial court found that it is truly a perfunctory investigation has been made twice, and thereafter directed to carry on further investigation. Against that order, I have filed this appeal. And
paragraph 4, what you are showing?
Paragraph 6 of that page 4, paragraph 6.
Chief Justice.
Yes.
Is it? My lord, after we have gone through the report submitted by the police along with annexure, we prima facie find that the investigating officer has not taken note of the public notice issued by the University Grant Commission in January 2016. By the public notice, UGC informed the public at large and students at that IIPM fifth respondent is not university within the meaning of section 2 within bracket F of the University Grant Commission Act 1956. Further, as per section 22(3) of the Act, IIPM does not have the right of conferring or granting degrees as specified by the UGC under section 22(3) subsection 3 of the said Act. It was further clarified for information that IIPM is neither entitled to award any UG or PG degree, including BBA, BCA, MBA degree, nor it is recognized by UGC. Therefore, the public and the students are informed that only universities established either by the Central Act or Provincial Act or State Act or an institution deemed to be university under section 3 of the Act or an institution established empowered by the Parliament to award degree can confer or grant degrees which are specified under the 156 Act under section 22(3). This is the University Grant Commission Act. A list of degrees specified by UGC was made available in the website for information of all concerned. Prima facie, we find that this aspect of the matter has not been investigated by the police. Further, we find from the annexure to the report submitted by the inspector in charge electronics police complex that the Mahatma Gandhi University has addressed the said sub-inspector of police is by said letter dated 5th December 2024. This is in this appeal proceeding, wherein it has been clearly stated that
Abhishek Mukherjee was a student of to admission নিল
Contentionটা হচ্ছে যে IIPM is affiliated to আমরা যদি দেখো statement of marks also
This Mahatma Gandhi University is recognized by UGC.
the Mahatma Gandhi University is
You took, let us understand, you took admission in IIM, that is 12 to 50. You completed your, the result was not given to you, maybe. Subsequently, that was produced.
not only givers, there was other givers that this institution has no authority to grant.
So you taking admission in that, you applied for bank loan.
yes
My lord,
18 lakhs bank loan was granted
750 7 lakhs
by which bank? HDFC.
HDFC.
Now that amount you had to repay to HDFC.
No, not yet. He is running after my client.
to bank
That loan was taken in which year?
এটা কি
2012.
That 2012 at the time of initial admission.
Very good. Now who is for IIM? You are for IIM.
No, no, my lord. I am for the
Who
CBI.
is for IIM?
IIPM.
IIPM.
IIP.
I am submitting. In read court, they appeared. They made submission.
Acha.
They made submission that Mahatma Gandhi, they have contact with Mahatma Gandhi University and they will produce the certificate from Mahatma Gandhi University.
Now in appeal, nobody is appearing.
In appeal, nobody is appearing. Initially, they have received, their advocate has have received copies.
Who was their advocate, sir?
Yes. My lord, in affidavit of service, I have stated. The affidavit of service দেখাও।
এই কোনো ওকালতনামা আছে নাকি?
বিশাল গুপ্তা
এই দেখো দেখো পেজ পেজ
4 to 7 বিশাল গুপ্তা সাগ্নিক ভট্টাচার্য
বিশাল গুপ্তা সাগ্নিক ভট্টাচার্য
Where you are getting?
from the order date
from the order dated.
Order dated
Order of-
7th April
no
3rd September, impugned order.
3rd September
before the read court.
Yes.
So nobody appeared in appeal. For respondent
affidavit
number
taken-
5 in appeal.
4 to 7 years.
Oh, 4 to 7
7.
In the writ petition. 4 to 7 writ petition.
Affidavit of service filed in court, but that will say that the advocate on record have received the copies in appeal court.
11.
5, 6, 7.
Affidavit of service টা বের করি।
এটা অ্যাড করেছে বলো 4 to 7
11 টা হচ্ছে ব্র্যান্ড অ্যাম্বাসেডর অফ
4 to 7 IIPM. IIPM. 4 to 7 IIPM.
IIPM এর DNR 205
শাহরুখ খান। না, না,
7
11 ছিল শাহরুখ খান। ওরা এখন ইয়ে করে দিয়েছে ওদের
শাহরুখ খানকে পাঠিয়েছে
expand হয়ে গেছে।
এক্সপেন্স
6 7 11
এটা কিসের?
12 11
Mr. Shahrukh Khan is one of the respondents.
was
yes
এক্সপান্ড
Mr.
করে দিয়েছে।
Devnath Ghosh represented.
Shahrukh Khan was brand
you are sorry
ambassador.
for
He has
that
taken
Mr. Bandyopadhyay
3.5 crores.
you are sorry for that
No, I am happy for Mr. Ghosh
And Mr. Ginodia as well.
and Mr. Ginodia.
Sanjay Ginodia, he was.
don't be jealous about his favor
A bit, little bit. I will not deny it, Mullah. I am a little
The
bit.
copy of the affidavit of service that Sarnik Bhattacharya
you are much more than the star
Hello?
you are much more than the star in this institution
one day did
you're a respected advocate
in page 4. Receipted copy at the bottom, Sarnik Bhattacharya.
তাহলে in the appeal this IIM is not appearing
No.
ব্যাংক না কেউ
জিপসি ছিল
12 থেকে 15 পেয়ে দেখো তো
12 থেকে 15
অ্যাপিল
বাকি তো কমে যাবে দেখছি
ব্যাংক HDFC ব্যাংক লিমিটেড আদিত্যপুরী কেও পাঠিয়েছে।
রিপোর্টটা ভাই সেন্সেল
এগুলো এক্সপান্ড হয়ে গেছে এদের এখন দেখছে কেন
অ্যামেন্ডেড অ্যাপিলটা ফাইল করে
করে দিয়েছে
এবার
রিট কোড এক্সপান্ড হয়ে গেছে কি দেবে ফ্যামিলি কপি না
a certificate from Mahatma Gandhi University. They are this stranger.
was it a correspondence course
No.
regular course
Regular course.
now this IIPM is still there
No, that has been closed. And they are all the IIPMs, all the units are almost throughout all the states or situated all these states. And after the decision of Delhi High Court taking the cognizance, hence they have only carrying on their business from Delhi unit. Their head office at Delhi.
yes
What was the student studying in IIPM? What was he studying?
MBA. They have taken admission for BBA and MBA degrees. And now,
So the mark sheet or the statement of marks would come from whom? The IIPM or the
mark sheet is coming from Mahatma Gandhi University.
correct?
They are stranger. They have the vice chancellor of the Mahatma Gandhi University in their report stated that they have no contact, they have no
How
relation.
is the mark sheet coming from the MGU?
That is the case.
That is
That
forged.
is the case. They have boosted the Mahatma Gandhi University to produce mark sheet and to justify their compliance.
Not just that, you see, Mr. Sarkar, in all these mark sheets, it seems to be verified by the Assistant Controller of Examination, Mahatma Gandhi University.
Yes.
Come to any one of the mark sheets, you'll find the stamp and signature of the MGU.
Yes.
page 36
no signature, no signature.
Take page 27 of, I'm looking at your affidavit of exception.
কেসে পার্টি করা হতো
Take your affidavit of exception.
That I have not. checked up. I am going through.
No.
This report. Their mark sheet. I am coming to the mark sheet.
Yes, kindly take page 27.
Report 27, 26 and 27. There are 5 copies of mark sheet.
Yes,
5 mark
so
sheet.
you see it's at the right-hand corner bottom,
Yes.
it says verified by whoever assistant controller of examination.
My lord.
So who is giving this? It's the MGU.
That is
Yes, MG. Mahatma Gandhi University's assistant controller.
36 টা দেখান না। Page 36 টা দেখান। Well, kindly comes to page 36. Point number 5.
Yes, I've seen that.
Totally.
Why 36? You take from 35, clause 2.
Yes, 35 and 36.
Yes.
So if this is right, then how can this be right?
Yes. Yes, they are producing.
Fourth certificates.
Well, that is the fact. By producing the document from somewhere else, they are justifying that that is their compliance for issuance of their certificates and the course, and they have taken that money. In the exception, I have stated I am not a student of MG University. That I have no relation with MG University. I have never studied with the Mahatma Gandhi University.
It was not in the prospectus.
You wouldn't have taken admission in the institute,
IIPM.
which is not, you cannot take admission without ascertaining whether it is affiliated to any university or not. Problem was created by you. When he went to take admission in IIM, it was incumbent upon the student to ascertain, because degree cannot be granted by the institute. It has to be under a statutory provision, and only universities have power to do the same.
That is the law.
The fault was yours that you obtained loan, took admission and pursued the course in IIM.
Advertisement throughout India, all electronics medias, everything has been stated that IIPM will confer BB and MBA degrees, MBA degrees, and they will provide job, etc.
Are you a student of MGU?
And Shah Rukh Khan was the brand ambassador.
No, but Shah Rukh Khan
Showing
was-
the faces.
It is, sir, what my brother is asking.
Were you a student of MGU?
No.
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 Come to page 35
35.
of the affidavit of exception.
Yes.
Paragraph 3.
Clause number 4.
3, my lord.
3 and 4.
3 and 4. Yes, Abhishek Mukherjee, son of Premananda Mukhopadhyay of 47 Kamalpur East, his Sasansa's address was the student of our university in 2015.
Then?
This is falsely written. I have denied in my exception. Exception.
Achha, show us the notification, advertisement on the basis of which you took admission.
My lord. Kindly have a copy of the writ petition. Stay application. Page 87.
So what is your prayer before us?
For referring this is 3 times FRT has been given by them. This is purely perfunctory investigation was made, and that is also proved before this court and the trial court also. So this matter to be referred to CBI, because this is a fit case for CBI reference, because there is national ramification. All these routes are lying throughout India. The person who has taken the money,
Chief, the order passed by
yes,
the coordinate bench.
upon prima facie satisfaction, chief has ordered that why this will not be referred to CID. CID, please.
Be happy
tell.
with that. Be happy with that direction.
No, my lord.
What no, my lord?
My lord, no, because The CID,
The case of
CID
CBI.
is not capable to conduct this case throughout India and abroad also. This is the in the prospectus they have.
It is not a case of India and abroad. It is a case dealing with the officials of IIM. So
My lord.
CID would be in a position to reopen the investigation and to take fresh steps as directed. CBI, on what ramification it will have? First of all, ignorance of law is no excuse. You ought to have been careful at the time of giving the 7.5 lakhs to this frivolous institution.
They have also, the bank has also granted that loan.
Very good.
That
Bank
one
will earn
presumption
interest.
is bank is granting
What is
loan
the problem with
is
the
also
bank will earn interest with that.
no, bank cannot do that.
Bank situated under their premises.
Bank's person is situated under their premises.
Now bank has been thrown out from the array of parties.
Well, at that we have made party. Now the order of the
Chief said that there is no, the coordinate bench said that there is no requirement of bringing in HDF.
yes at this stage. But if the investigation, if they found the investigation will be made against them.
Yes, what is your stand, Mr.
But
Baba?
in terms of the last order, my lord, we have filed an affidavit. My lord, we were to show cause as to this part, my lord, where there is a primary observation. Now, my lord, after going to the lordship's order, my lord, we have also seen that this letter we have received from NG dated 5th December. My lord, that was probably not appreciated in the right light while filing the third FRT. So, my lord, we have given a prayer because, my lord, what has not, I'll tell you, lordship, what has not been investigated.
Two things.
Yes, my lord,
Two issues have not been investigated.
when
First
MGU
is that you are not, the IIPM was not affiliated to UGC. Second is that there is no agreement between MGU and IIPM. These two things have been glossed over by the concerned
but
officer.
as far as the first part is concerned, well, this we have seen. This we have seen. That is why we had approached the university. That without the UGC Malad affiliation, how could UGC recognition, how could this institute run? That is why we approached the university. But when we approached the university, we got the letter of 5th December. Why I say that 5th December was not appropriately considered, because your lordship will find in one breath MGU is saying that we have no agreement with IIPM. In the second breath, they are saying in 3 and 4 that we have issued mark sheet. So there must have been some transfer of money, because money was paid to IIPM. If Abhishek Mukherjee is stranger to MGU, MGU will not issue mark sheet to Abhishek Mukherjee.
Exactly what I was asking him.
Yes,
But he
so
says the mark
kindly
sheet is
see
also
where we have missed it. We have missed somewhere. But we have cross-checked our investigation. We have missed investigating this part of the complaint and the contradictions, that once MGU is saying that we have no agreement with IIPM, then how did the name of Abhishek Mukherjee come in the list of students of MGU? He is giving examination and mark sheet is being provided to Abhishek Mukherjee.
Students in MGU.
Because MGU
MGU that
has issued mark sheet. That means he has taken the examination of MGU through IIPM.
That's what I was asking.
Therefore, there is 5th December, we have made a mistake of believing 5th of December, when 5th of December reeked of several contradictions in itself.
Kindly have a look.
It may also.
If your lordship takes page 35, since your lordship is taking from the exception, kindly takes from the exception, my lord.
Now come to your report. Yes.
My affidavit filed today.
No, your exception.
Their exception to my report. We had filed a report, and they have filed an exception annexing my report. So my report and exception are all together. Well, the annexures to their exception are what I produced in my report.
No, in your report you did not.
Kindly have a look to.
In your report you did not.
Page 35 once.
Well, my report.
You did not produce the letter of 5th December.
Yes. Well, it is my report dated 6th of April 25.
Yes.
6th April 25 is a report signed by Inspector in Charge, Electronic Complex Police Station. To this, they filed an exception annexing my annexure. 6th April 25.
No, that 12th June 25.
6th April 25.
12th June.
12th.
That's your last report.
That is what we are filing today.
Yes.
Well, not that. Prior to this, in the read
Oh,
court.
which was considered by the coordinate bench.
Yes. This is the report, same report we filed before the Honorable Single Judge also,
No.
dated 6th April 25.
No.
No, sorry. We filed
Absolutely
it.
false.
Don't use the word false. We make mistakes while. Right, we have filed it in the MAT. MAT 1892, we have filed it.
No,
But it should be on the record, my lord. The coordinate bench has considered this. It looks like a letter. But it says to government leader. Copy আছে? না না আমারই নিয়ে না কেউ এরকম এই লিখো পেয়েছো না দুটোই থাকবে না দুটোই থাকবে আরেকটা অন্য ফাইলে দেখুন
এটা লাস্ট রিপোর্ট
This is 16th. This is 6th April 25. Here your lordship will find all these annexures which have been annexed by the in the exception. These were documents produced by us in court.
My lord, may I suggest something to assist the honorable court? ওনাদের আমি তো চাই না
ও চাই নাই
ওনার কাছে যে মার্কশিট গুলো আছে সেগুলো তো প্রডিউস করলে বোঝা যাবে যে ডিসক্রিপেন্সি আছে কিনা দুটোর মধ্যে না না ওনাকে তো কিছু মার্কশিট ইস্যু করা হয়েছে they have admitted
Let's have a look to page 35 once. Of clause 2, page 35. Yes, 5 of exception, of my exception.
Let him finish now. Let him finish his stand. Yes.
If your lordship has got the report, your lordship will kindly take the second page bottom.
ঠিক পেলে রিপোর্টটা
Second page bottom.
Second page bottom.
Referred to by the coordinate bench. Yes. Yes, what you are showing us.
But there, my lord, we had produced these documents, which your lordships are finding at pages 23 to 27
Very
as
good.
well as 35, 36. The document produced by us. Now, my lord, there your lordships will find where we have gone wrong is, my lord, these contradictory statements by MGU. My lord, just a note that MGU is not a party before your lordship. Never was a party before your lordship. MGU is not before you. But point number 1, they say that yes, MGU is recognized use for group. Number 2, they say that no, there is no agreement with IIPM. And they say,
Where are you reading?
I am reading at page 35. If your lordship taken the exception, page 35. In that
35 of the exception.
your lordship
Clause
will find an annexure.
Oh, page 35. Yes, you are showing that.
Same thing, my lord.
So this letter you got in course of the reinvestigation.
Part round of investigation.
Acha, please give us the dates. First mistake of fact was on.
But I have given the my exception.
Can you give us the date?
I have given.
Yes.
That means list of dates is there.
That page my exception, page 9.
My lord, 30th November 2016 is the first FRMF, mistake of fact. 30th November 2016. Then there was a direction of reinvestigation by the learned ACJM.
30th September
30th November 2016.
First FRT.
60.
FRMF.
Then
Then second FRMF 25th of March 2018. 25th of March 2018.
Then Naraji.
And then Naraji.
And it was reopened.
Not Naraji. Then the Honorable Single Judge in the impugned order asked us to conduct further investigation.
Fresh investigation.
Achha, Naraji was filed by them.
Between the first and the second FRMF.
That Naraji was also dismissed.
No, Naraji was allowed by the learned SCJM directing us to reinvestigate. Which boils down to 25th of March 2018 FRMF.
That was on 16th of May 2016.
30th November
The order of
16
reinvestigation.
May 2017. 16 May 2017.
This was the Naraji being allowed.
Yes.
Very good. Then
in the interagnum, we obtained that 5th December letter from MGU. And the last FRMF was filed on 28th of February 2025.
now you yourself has now made a
I have made a prayer
for the
for reopening of the investigation.
Where
the next date has been fixed on 28th of December. 18 December 25.
Yes, now you show us what according to you were the infirmity which you would have.
Which we have ourselves noticed that at page 35 your lordship will find that when the MGU has stated that there is no agreement with IIPM, and at 36 they have stated in point number 5 that IIPM Kolkata has not merged contract or agreement with MGU University for completion of any kind of course. How Abhishek Mukherjee appeared in the role of students of MGU, took the examination, and mark sheet was issued to him, which has been confirmed by MGU in serial number 3 and 4. When we when
So that goes against the petitioner. Maybe.
we should have investigated MGU part as well. We should have investigated the MGU part as well. We have recognized our problem.
And the other one? You said
this
2 points.
This is the point.
That you have not dwelt on the
MGU part.
MGU
part. Though before filing the third FRMF, we had this letter on both. And same with the petitioner also. Petitioner has not made them parties, or they had no allegations against MGU.
Oh, MGU is not a party.
Never, no, not even before the Honorable Single Judge. So never a party.
So what was their complaint? They said that they have been defrauded.
They have been defrauded.
Where is that complaint?
On the virtue of the brochure.
Where is that complaint that is there? It must be in your this one.
I'll give you that. I'll just Malad, it is at page 154 of the stay application.
Correspondence to Himachal Pradesh University, correspondence Supreme Court, Himachal Pradesh University is in Andhra Pradesh or some state. He can have subcenters only on his state. But he cannot have any substance beyond the periphery of the state where he is established. So, admission meaning. Affiliated in a particular state, and whether that means যেটা উপরে
Yes, 154 Malad starting.
Page 150.
54 of the stay application.
কথাটা বের করার দিকে এখান থেকে বুঝতে পারছি কত ওইটা দেখতে হবে
একটা লোককে কিন্তু হচ্ছে কি সিআইডি করলে
Now, Mr. Bandyopadhyay, just we are wanting to share this. His grievance is he had been misled, he has spent the money, he has not got the money. Investigating officer rightly, wrongly has conducted an investigation. Today, even if we direct CID or CBI, what will be the outcome? A fresh investigation will proceed against a non-entity. They will not be able to venture to find out the persons who are attached, who were attached with IIM. I do not know. Now, can we do this? Can we ensure the presence of any of the officials of IIM, subject to what he gives the particulars? Because investigation in the long run, what will happen? Suppose CID or CBI say it will take 2 more years to file a file. Maybe it will come down to a final report.
Yes, that there was a
The person goes on suffering, and it is a fact that there is some stinking malafide involved. That there may be a collusion, maybe this has been done in the correspondence course matters. You know, we sitting in division bench, we have delivered judgments to that.
Well, he had two angles of complaint. One is paying that 18 lakhs. Second is job at the end of the course. But this is a very important part. The breach
That
of
is
trust.
a legitimate expectation which he would.
No, there is a breach of trust that they are complaining of. So I just wanted to add to it, Malad. If your lordship sees the complaint at various places, they have stressed on this aspect that course and service at the end of the job. Court.
Any of the officials of IIM are still there? Do you know? Do you have any idea?
My lord, one official.
IIM is not coming before us. Do you have any official in the array of parties who
Yes,
we can personally direct to appear?
My lord, in Calcutta, there was an official.
Show us that.
Orindam Banerjee, dean of IIPM campus.
Respondent number 6.
Aniruddha Banerjee, 16. Respondent number 16.
This office has gone. Presently working at BIPS Kolkata.
He was working there at that point.
Director 6, 7. 6 and 7.
And 6 and 7, the directors who are residing in Delhi.
Orindam Chaudhary, Dean of Education Faculty of 4 and 5.
Well, Rojita Chaudhary, we had given section 91 notices. She came and she said that we could not run the. It's there in the chart sheet. But this running commentary is very difficult, Malad, from my learned senior. It's there in the. I'm reading from the chart sheet, not something I'm saying off the cuff.
What did she say?
But she said that due to technical problems, could not run the institution. We have closed it. We gave intimation to all the students to.
So why did you take the money?
To collect the mark sheet. This particular person did not come and collect the mark sheet. The mark sheet kept lying with us. The lordship has found in the coordinate benches order. After that, they have taken it.
But that mark sheet is a scrap of paper. He will not get job on the basis
because there was no affiliation.
So how you so easily let go that person? Because he said we have taken the money, we have passed we have published the result.
Your lordship takes, Malad, this page 163.
You should have interrogated these persons.
We have interrogated this person.
7 and 16.
163, the first FRMF, your lordship will find. affiliation is the thing. But MGU has affiliation. MGU is recognized. His mark sheet is not scrap of paper. MGU is there. পরীক্ষায় দিইনি আমরা এক্সামে দিইনি রেজাল্ট বেরিয়ে গেছে পাস করে তাই করে
My lord, may I make one submission? My lord,
Here for
I am for the CBI, although whatever falls from my lord.
we are trying to find out whether the problem can be solved.
Yes, my lord, just
can be mitigated.
just from the, as a member of the bar, I'm making this submission. This lordship, if this MGU, if these people can be brought in, whether the mark sheet that they have supplied, it may happen that some of the officials of MGU might be in connivance with
Matter of
IIPM.
investigation. MGU
Right, my
will
lord.
never admit that I have got any money from
No,
IIPM.
no, whether at all these mark sheets were issued by them.
No, they are
It may so happen.
Page
They are
35.
Yes, my
saying
lord.
that
They are saying it may so happen that this person who has issued this letter might be in connivance with one of the persons of IIPM.
But MGU
Because
is
of this
not a-
investigation, this notice has been issued to cover up the entire gamut of events. It may so happen that this particular assistant control who identifies himself as the assistant controller, or whether the vice chancellor has actually signed this, or some peon has signed it and sent it to the police officers.
MGU is not a party here.
My lord, that is what I'm praying. If
So that has to be gone down. We cannot take the role of the CID officer.
definitely, my
Or
lord.
that investigation
This is just my understanding I've shared with my lords. If something falls, because
We have heard
there
you.
is something wrong.
Let us see whether you can mitigate the issue. Whether you give a notice to these six respondent numbers 6, 7, and 16.
6, 7, and 16. 6, 7, admittedly, as per submission made by my learned friend, he was there. He came to their in response to their investigation. Rojita Chaudhary.
Very good. You give a copy to. She was not arrested.
Yes, but came to them.
Now this Orindam Chaudhary, where does he reside? You have the address, postal address.
Daily address.
Eh?
Daily address.
Daily address.
But they are perhaps husband wife.
Perhaps they are. That's how they're described. Rajita Chaudhary is described as his wife.
এই লোকটাকে দেখে আমি চিনতে পেরেছি পোশাকটাতে পাঠানো হচ্ছে এই যে পুলিশকে দিয়ে সার্ভিস করিয়ে দেবো সব জায়গায় বিরাট করে ছবি দিয়ে কয়েকশো কোটি টাকা করে নি এখন প্রকারটা হয়ে গেছে
বলা হয়েছে বুঝিয়েছে সব বুঝিয়ে দেখে ধরেছে
Anybody appeared on their behalf 6, 7, and 16 before the read court?
Yes, read court. Read court they appeared.
Who appeared?
That advocate.
Who is that advocate?
Advocate name
Shagnik Chatterjee.
Shagnik
Where
Bhattacharya.
from we get that? Where from we get
Impugned order.
Impugned order.
Affidavit from the receipt copy, service receipt copy.
Page number 29.
In the impugned order as well, my lord. Page
And
22 of
in
the
the
memo.
impugned order also it has been recorded.
Memo of appeal, page 22.
Number 29 of affidavit of service. In affidavit of service,
records reveal that by an order dated
order dated what? Page 29. Order dated.
you this Mr. Utto
7th April 2020.
money gone.
হজম হয়ে গেছে
Yes. No. Mahatma Gandhi University is a fake university.
No.
IIPM.
I would.
Institution is fake. Who got that money?
By
And the degree, my lord,
record revealed that by an order dated 7th April 2025,
59 page.
according Mr. Mojum, just call Mr. Banerjee. No, বলে দি যদি চলে গেছে। Mr. Bandyopadhyay, we are keeping, instead of second, we are keeping it on 8th July. You ask your investigating officer to contact them over telephone also. And to ensure their presence, though we have not directed that.
But if that phone number is available to him,
All will become available once you ring up. You have to ring up the investigators. Everything will be. Yes, next. Oh, 9 July, 8 July. Yes, next.
And I'm for the appellant.
My lord, I am for the respondent, my lord. My lord, due to bad weather, my lord, learned counsel is not present. My lord, I am not
Bad
praying.
weather.
My lord, I am praying for not today, my lord.
This is the second adjournment, my lord, on their behalf. This is the second time adjournment they are praying for.
Let us see whether the case is bad or not. Then you will succeed. You are for the private respondent.
Respondent, my lord.
And I am for the private respondent in the writ petition and appellant before your lordship.
So how you are agreed by this order?
Yes, my lord. Kindly see, my lord, the second page of the order. My lord, kindly see, in view of the contents of the police report that there is a sharing in the Brickfield business of Bapun, the Brickfield in ratio of 70:30, I am of the view that the nature of the offence complained of should be heard by a civil court. Next line is very important. The petitioner would in the circumstances approach the civil court for appropriate remedies so far as the share of the business is concerned. However, it appears the report from the report that admittedly, there is no admission, that there is 70% share of the petitioner. As such, it is if the petitioner intends to enter and there is resistance, police would ensure that there is no breach of peace and tranquility and no untoward incident resulting arising out of the strained relationship between the parties. Now, my lord, kindly comes to my stay petition.
You are only aggrieved with that word admittedly.
So admittedly is there, my lord. In every paragraph of the writ petition, the writ petitioner has pleaded that she is the partner of the my lord with me. Now, my lord, kindly see the document. Kindly, my lord, comes to my lord, annexure A, page 7 of the.
Was the partnership?
Yes, that is what I am showing. That is what I am showing. The annexure A, my lord, page 7 of the stay petition, and this was deliberately not annexed in the writ petition. I have annexed page 7, my lord, annexure A. Kindly comes to, it starts from page 7, kindly comes to relevant portion at page 11. And this is the registered agreement. Kindly comes to clause 7. Who are the parties? A, Devobroto Kanji 30% and B, my client Motiar Rahman Molla. And Devobroto Kanji is certainly not the writ petitioner. Writ petitioner is the daughter of Devobroto Kanji, and Devobroto Kanji is still alive. I have no privity of contract with Milord, the daughter of the. And Milord, the learned trial judge refers it to the civil court. But still, Milord says the writ petitioner, if she wants to, Milord, enter into the Brickfield, she will be escorted by the police. In every paragraph of the writ petition, she has claimed to be the owner of the.
Not escorted by the police.
No, Milord, yes, assisted by the police. Assisted by the police. And in the writ petition, she has everywhere stated she is the owner. And this document has been deliberately, my lord, suppressed in the writ petition.
Yes, Mr. Mondol.
It's a totally civil dispute, my lord. A petitioner came before the trial court, my lord, for inaction of the police.
Yes. Yes.
My lord, on instruction on my learned senior, my lord, I submit that there is a civil court, civil suit is pending before the lower court, my lord.
Civil suit is pending.
My
You are a party to that.
My lord, I need brief, my
You
lord.
bring the plaint.
My lord, brief is not my here with me, my lord.
This is the second adjournment. The last occasion, they also prayed for adjournment.
Lord, kindly list this matter tomorrow, my lord. Kindly, my lord.
No, if a civil suit is pending, there is a partnership firm. There is a dispute whether you are a partner or not. They are disputing your partnership. So suit was filed by whom? By your client.
My lord.
You have filed it. To obtain an injunction there that you allow me to enter. Once you get that order, we will direct the police to give you assistance. Without that, how can this order be passed?
Lord, at that time, I don't have any copy, my lord. List the matter tomorrow, my lord. Kindly.
Yeah, hard, Mr. What is
Kindly stage the operation of this order. My lord, police, they are already activated.
ডেটটা দিয়ে দিন।
I'm for the appellant election.
Lordship, I am for the private respondent number 7.
The two brothers, electricity.
The writ petition was filed at our instance. This was about new connection. We have complied with all the formalities. They have made separate applications for themselves. They did not able to fulfill their part. The connections were not given. On last occasion, this bench
Lordship,
given everything.
Before starting to hear, kindly have a look at this. What the respondent authorities have done. Lordship, when the matter is pending before your Lordship, how the respondent authorities can initiate the criminal proceeding against me?
I tell you, Lordship, subject to Lordship kind approval.
And Lordship, what?
I will highlight the entire issue.
And Lordship, I have filed an application. Kindly go through the paragraph 9 of my application.
কপি কপি দিন আমাকে কপি দেন
ছিলে না
কালকে
ওরা নেয়নি
কালকে ম্যাটার হয়েছে
কপি দিতে গেছিলাম
আমাকে দিতে যায়নি কেউ
Till date, I am living in darkness. The petitioner is blessed with a daughter
There are reasonable grounds to question you. Certain
who is pursuing her studies.
কি কাগজ দিলেন আমাকে একটু দিন
Informing that during the investigation of such and such. 30/5/2025 এরা complaint
বলবো
CSC করেছে
may I
You lodge the complaint.
may I yes Lordship kindly see this report Lordship
No, tell us now what is the problem.
kindly see the entire scenario will come into the picture Lordship
What application you have filed?
Lordship, can to
Lordship kindly hear me for a moment
এসেছে can to এসছে There had been 2 occasions they are resisting us.
এই রিপোর্টটা আপনি একটা রাখুন
The licensing authority.
আপনি একটা
Thank you.
Can to para 9.
Lordship, kindly allow me for a moment.
আমাকে একটা দেবেন রিপোর্ট।
আমার কাছে একটাই আছে, আমি পড়ে দেব।
Even the licensing authority is fed up with the approach they made.
রিপোর্টটা দেওয়া আছে?
They are simply flouting with the order of this.
But wait, sir, how many
About
times?
on your worship.
অ্যাপ্লিকেশন দিন একটা আমাকে। দিচ্ছি।
Yes, what you are saying?
Your Lordship was pleased to pass this direction on 22nd of May 2025. Where your Lordship was pleased to direct, in presence of both the appellant as well as the private respondent, to give the new service connection to the petition, to the appellant, Lordship. And it is admitted that no cross appeal has been filed by either of the parties, either from our side or from the respondent, private respondent.
Against what?
Now, on 22nd of May, this order has been passed, and we have engaged the agency to install the new service connection on 27/5/2025. Now, on that basis, your Lordship will find that we got the stiff resistance in spite of this order, and in presence of the private respondent, we got the stiff resistance from their end. And Lordship, kindly see the next page, Annexure 1, in the report.
Yes.
Here, there is a stiff resistance. We got the signature from the wife of the appellant, that is the Shreya Patro, and the private respondent refused to sign on the same. Now, subsequently, this has been intimated.
Why you are opposing?
But this is the precarious situation.
Question of opposition, Lordship.
Then
No
what
question
is?
of opposition, Lordship. When the personnel went, the respondent number 7 was absent in that home, and only the mother was present.
Acha.
And Lordship, and almost illiterate woman, village woman,
Mother was
Santibala, Lordship.
Acha.
Lordship, how can she?
Amol and Madhavi were not there.
I am for Amol.
Who is Madhavi is your wife.
Madhavi is my wife.
So she was also not there.
No, Lordship.
So only the mother was.
Only the mother was there.
So then tell us what is the problem now?
Lordship, problem I have stated, kindly go through the para 9.
Para 9?
Of Can 2. My application. Only point, nothing else. The personnel said that after a few days they would come back with a new angle and they would install the meter. Till now they did not come. This is the situation. Nothing
Allah,
else.
this is the second instance.
After Lordship's order, Lordship, how it is possible I will resist?
Allah, this is
That angle is still there, it is supplying to you. So that angle, they will add one wire and it will break down.
Lordship, that is almost reached.
How you saw it or what?
The fact is that
You saw the angle or what? Huh? Almost wretched.
Lordship tussle between Sasuri and Bouma. And
now
and the distribution council has been throttled.
Lordship, Shantibala.
Now, if the Shashuri is called to the police station, what will happen? Tell us. Suppose we do not interfere, then what? An old lady, she is giving an undertaking.
Criminal cases and civil cases are pending.
Forget about that. You have undertaken before us. We repeatedly asked you. You said that yes, no problem, we can give connection. We recorded that.
Lordship.
So after this, you should not have acted in this fashion. They might have gone. You might have abused them and sent them away from the home. They are also staffs of a particular statutory organ. So what they will do? They will say High Court order not compliant. Let us file a complaint, and the complaint will immediately be taken because
Lordship,
the High.
Lordship, they should install a new meter angle and everything will be done without prejudice. Lordship, nothing else.
What meter handle will be passed?
Lordship, the angle in which the
Well, what I will say, Lordship, my humble submission before, but that cannot be taken into consideration.
You tell us the date and time.
Yes.
When they will go.
This assistance there. Anytime, Lordship, any date, any time.
No. No further angle, it will be hanged from your angle. Finished.
And police help is necessary. Yes,
Your service connection will
and
not
Lordship
be
kindly
disrupted.
see the annexure 1.
Wait. Your service connection will not be disrupted. What is your problem?
Lordship tomorrow.
Huh?
In this annexure 1, here it has been specified. Allegation is that this private respondent was present. অমল দত্ত ও তার মা শান্তিবালা দেবী পাত্র বাধা দিলে মিটারটি বসানো যায়নি. In Bengali, it has been written. What can be done? Here, my learned friend is saying that they are not going to object, and there was a different scenario. My police help is essential, Lordship.
অমল পাত্রকে থাকতে করতে হবে। এটা কি করা যাবে? এটা বলছে implement a new metal angle কি করা যায় করে দিবেন।
Can you, Mr. Dr. Sarai, can you put in a fresh angle there?
That I cannot say that, but whether it is absolutely necessary or not. If it is necessary, they should make an application before the authority. There is no application pending before.
Not their one. Through that angle, they are enjoying connection. No?
Yes, they are enjoying connection, and the expert has gone there and said that it can be done. It is not at this juncture necessary, Lordship. If it is at all necessary, then inspection is required to be made, Lordship knows.
No, this is a mother-in-law and daughter-in-law problem.
Technical issue, they have to file an application before the authority. We have to go there and we have to make an inspection whether at all necessary or not. If it is not necessary, then I cannot.
When can your staff go? Tomorrow?
Tomorrow, some breathing space may be given subject to your Lordship kind approval. Some breathing space must be given.
Day after tomorrow?
3 days time should be.
They are without electricity.
But we have tried all endeavor, Lordship, seen that Lordship kindly appreciates.
This lady will be arrested. Apply your good office, send to your person.
Here agency has to be recruited. Lordship knows that the agency has to be recruited because some time should be given, because he has been recruited, then again further agency has to be recruited.
Are you drawing it through that metal angle? Is it a fact? That also you do not know.
No. Because the new service connection has to be given on the last occasion. I have drawn to your Lordship kind attention that this is the load factor is most important.
That we have understood.
Yes. Because we have to enhance the load and have to draw the line from the main service connection. This is the technical issue, Lordship. Utmost subject to your Lordship kind approval. Lordship kindly give some breathing space. We will intimate the police authority. The police will render all sort of assistance if we get the resistance, and the cost to be borne by the appellant.
Sir, if you don't solve your problem, we have to intervene. Want that old lady to be taken into. This is not feasible.
Lordship, my instruction is the angle should be exchanged at our cost.
Again, there will be problem. If there is any problem with the angle, you are ready to apply. Why will you unnecessarily pay the money? The angle is there, they will connect through it. And if there is any problem with it, they are also staffs of that institution. All right, you tell us the date and time. I will be there. Your Bimal Patro, when he will be there. Otherwise, he will be arrested. If you create any sort of problem, after
Lordship fix the time and date.
Yes. Ashok,
At least some breathing space may be given, Lordship, so that we can recruit the agent.
you telephone them.
I will, but
Today is Tuesday.
Pass over.
no, Lordship, pass the order on next Monday, within that Monday, Lordship. That will be
Mr.
serve the purpose. And police help, Lordship.
No.
Dr. Shahadai, learned advocate appearing for WBSCTCL, submits that
No, it's three brothers, one brother.
Yes, next.
Yes,
Meanwhile, I am
for the-
appearing on behalf of the Contempt Respondent Union of India, led by Mrs. Chandriana.
Yeah,
But
but-
just now I have received the
Yes,
exception
yes.
petition.
I have just sub to my learned senior. My
The
lord,
problem solved or no?
My lord, no. My lord, here, my lord, there was a direction that so that the petitioners would be, my lord, getting the grade pay to the tune of 4,600. That was the direction which, my lord, they have challenged unsuccessfully up to the Honorable Supreme Court. And thereafter, my lord, my lord, I have specifically stated in my exception to the compliance report, my lord, they have, my lord, adjusted.
It was ordered passed by us.
My lord, the order, the original order, my lord, that have been passed by my lord Justice Matre and your lord.
Oh, acha, then we can hear.
Yes, yes, yes.
Now then what happened?
Milord, kindly
Oh,
keep it
it
next
that
week,
matter.
Milord, exception petition is
So,
just
madam,
now. I
what
have-
exception? We will call your clients. Let them be here. Exception. Supreme Court rejected. Still you are dilly-dally.
Milord, I will take instruction from my client.
Madam, what is this happening? We believe you.
Kindly fix it next.
On the earlier, on
Mrs.
the,
Alam
on
is
the
here.
earlier date, we were
Mrs.
about
Alam
to
is-
issue the rule upon this person.
Milord, they paid the 38% the refund one. They paid. They paid Milord refund one, and kindly see Milord para 13 of my affidavit of compliance, Milord.
Where is your exception?
My lord, my exception is
A affidavit of compliance they file. Now, what is the problem? Tell us. Now.
yes, my lord. The problem is, my lord, the MSCB benefit was granted from 2010 to 2014. My lord, there are three problems. One of them is this: 10 to 14. My lord, then they, my lord, they recovered that. This honorable court directed to refund and continue 4,600. They refunded 10 to 14, but from 14 onwards, my lord, up to 2020, they, my lord, made payment of my pay to the tune of 4,200, not 4,600.
So why didn't you tell us that at the time the matter was moved?
My lord,
Contempt when it was moved.
my lord, in the I tell your lordship, my lord, when this the compliance report has been given, my lord, the document, my lord, that was annexed in
No,
that
this when was our order passed?
back in
The writ petition.
yes, in 2016, my lord. I tell you.
What did we direct?
To, my lord, pay to the tune of 4,600 specifically. Grade pay to the tune of
If
4,600.
you allowed orders set aside, shall be entitled third final in the grade of 4,600. Where is that order, Mr. Rai?
My lord, order of the
Grant denial of that grant.
yes, my lord, it is your lordship would see. My lord, the exception, though, my lord, the commissioner did not yet put the signature. If I just can take your lordship, my lord, to 2 pages, my lord, because this is why, my lord, I said this fault, my lord, goes on me because I could not, my lord, sub upon my lord senior, my lord, within time. I just sub today.
Give a copy today.
Well, I have received copy the next week, Milord, kindly.
Madam, you take time, but tell us when you will do it. Because we are contempt, na, we are not in
Yes,
a position
yes.
to take up these matters. You
next-
talk with your officer and tell us. If we thought that the matter would be resolved, but it seems that there is
Milord,
problem.
2 weeks.
So from 2014 to 2020, they have paid you how much?
4,200.
So that 400 rupees is the
They did not. This is
grade. There's a separate grade.
yes. That is a separate grade altogether, which carries, my lord, different incremental benefits as well. They, my lord, denied, my
You
lord,
have to
paying that.
show us the order impugn, na? What was the order? What was the rejection?
My lord, that your lordship will find in the, my lord, the WPCT matter, my lord,
Next
original.
Wednesday, God.
Milord, 2 weeks times, Milord, I will.
Uh-huh.
2 weeks times, Milord, kindly 2 weeks times, I will take it.
Come on 2nd July. 2nd July, উপরে রেখে দিও।
Great.
And madam, you ask your officer if this is a genuine claim, let the amount be disbursed.
Or I have just given the copy of the exception today to my learned senior.
Just
It is written in that exception also. My contents.
But that you have not affirmed it, na? We cannot
Yes.
record an
Yes,
order.
yes. Great.
2nd July রেখে দাও।
Second.
চলো রেখে দাও। ও দাঁড়াও পরেরটা আছে। এটা ওইগুলো সব নতুন ম্যাটার ঢুকেছে।
My lord, I am for the private respondent.
I appear for the appellant.
For the state respondent, lordship.
But this arose from
the urgency, Mr. Oyundar.
Not the proceeding before the authority is on, despite the pendency of the appeal, the scope of evidence has been closed. Despite a request having been made that the appeal is pending before the division bench of this honorable court. This was done on 27th of May.
27th May.
My lord, as such, there is no stay in the proceeding. In the writ court,
দেখি কি হয়েছে। When is the next date, Mr.
19th is the next date, my lord.
19th of June.
June, yes.
That is day after tomorrow.
Day after tomorrow.
Opportunity to cross-examine the OP was closed.
Because 3 times the OP did not appear for the proceeding without having any stay in that regard.
So very good. Give another date. My lord will be returning on 21st. 21st, the regular bench will be in Sisin. You have stopped the evidence.
No, yes, my lord. No.
Next date you proceed. They will be prejudiced. At least they are entitled to have the matter heard.
Okay, my lord. My lord.
Give a next date of hearing after 2 weeks. Tomorrow you are appearing for the officer.
No, I am for the private respondent. She is appearing.
For the state respondent.
The question is whether pension is wages or remuneration. That's the question. If it is wages, then the authority would have jurisdiction. If it is not wages, then it is devoid of jurisdiction.
Have it adjourn it for 2 weeks so that they can get an opportunity. Then Justice Bharadwaj will be back on the 21st. Then you can have the matter heard.
So we record that.
Yes, lordship.
No, without instruct, will it be a judicial order? Let it be a judicial order. আরে না ও তুমি বোঝো না দম করে ঘাড়ে এসে যাবে কোনো ইনস্ট্রাকশন নেই
You are appearing for whom?
There are several matters, my lord. One of matter I am appearing. Item number 6.
There are 4 matters.
So very good. We are keeping it tomorrow to be mentioned. You take instruction from your officer. If you say that it is not possible to give such an undertaking, then we will look into his. Otherwise, we will record you are appearing on his behalf.
Yes.
Then the next date would be the hearing of the matter will be deferred for 2 weeks. So that the regular bench can. কালকে to be mentioned রেখে দাও। Oh, these are 4 matters are same.
Same. The matters are same, my lord.
Oh, same.
From the same order.
4 matters are the same.
4 applicants, 4 applicants.
You are for whom?
I am for in all cases. I am for respondent number 3. That is private respondent. Hey, এফিডেভিট গুলো ওকালত গুলো জমা করেছিস? ওকালত গুলো জমা করেছিস?
চলো ঠিক আছে। দেখে দাও।
Yes. Lord, actually, I shall take your losses 2 minutes.
We have heard you, Mr. Chokut.
Yes, only 2 minutes for a document.
We will give 5 minutes to the Advocate General.
Then kindly give me 1 minute.
30 seconds. 30 seconds.
Now, my lord, I have already submitted that the cabinet committee of the government of India, headed by the Honorable Prime Minister, approved caste enumeration in the ensuing census. This is the decision I am handing over. I am giving the copy.
What is that?
The decision of the cabinet committee.
Yes, that you gave yesterday.
Yes. No, I could not hand over the document.
Yes, you gave.
I gave.
Yes, yes.
Then may I give it to the
No, once given, not returned.
No, kindly now only I shall be placing 2 pages from the affidavit of the commission.
Well, I am appearing for the respondent number 2.
Yes.
I am appearing for the respondent number 2.
Who is respondent? Kindly come.
Who is respondent number 2?
Secretary.
Secretary backward. Kindly come to page 214 of the affidavit in opposition of the commission. Para 304.
Judgment.
Second part. Second.
ওদের opposition. কবে করতে হবে? এটার opposition.
214.
Yes, 214 page para 304.
Yes, please. Commissioner opposition.
It would appear from minutes of discussion before the NCBC on page number 47 of his affidavit in opposition that the NCBC specifically asked the state as to what was the procedure adopted by the state in identifying and classifying the classes from Muslims religion as other backward classes in the state. The NCBC thereafter at page number 62 in the minutes of discussion observed that several classes who previously belonged to the Hindu religion had converted to the Muslim religion. However, the state was not able to furnish details as regards such conversion. This fact of providing reservation to this conversion procedures will have a dangerous demographic effect, whether this is permissible, number 1. Second, kindly come to page, there are page 215 is the losses observation in the judgment, and the last one is page 348. Page 348 of the affidavit in opposition of this state commission.
Yes.
Towards the middle and thereafter. Members 348. Members have expressed their deep. This is the minutes of the 460th meeting of the West Bengal Commission for Backward Classes held on 17th February 2025 at 5 p.m. Members towards the middle, my lord, members have expressed their deep concern about this settlement that has resulted due to pendency of the litigations before the court of law. The chairman prepared a report in December 2024. A copy of the said report has already been given to the state at the appropriate level. Copy is circulated amongst the members today. The members are aware 114 communities earlier designated as OBC stood set aside in view of the decision of the Honorable Court in a bunch of writ petitions filed on such and such date. Then kindly page 354. Come to page 354. Towards the bottom. Page 354 towards the bottom. Last
354.
354 towards the bottom. Last but one. This is the minutes recorded by the chairman of the state commission in his meeting of 460th meeting. Now page 354 towards the bottom.
Yes.
They would all express deep concern about the communities whose designations have been struck off by the Honorable High Court by the judgment and order impugned. They means members. They means members. This is the observation. This is the observation of the commission. Commission is deep concern.
That
So the
express deep concern about the communities.
Deep concern. So what is the concern of a state commission? This is an independent body in a welfare state for reservation. Communities. And communities. Therefore, this will the pre-decision process before actually entering into the survey. And finally, your lordships are aware that once a judgment is declared alter virus, whether retrospectively or prospectively, there is a law prevalent in your country by a legislation which is called Validation Act. Without implementing a Validation Act or enacting a Validation Act, whether the judgment can be frustrated by any other procedure. These are the submissions. Very good.
Yes, Mr.
Now, my lord, so far as the commission's actions are concerned, Mr. Mozumdar had made his submissions yesterday. Now, my dear lordship desires to hear me on behalf of the state as to what actions the state has taken, my lord, post delivery of the judgment of this honorable court, and pursuing to, my lord, whatever actions have been taken by the commission, West Bengal Commission. Now, my lord, I have my submissions to make to justify the actions of the state, but as I stated yesterday, today also, my lord, I start by saying that the matter is pending whole hog before the Supreme Court. Therefore, my lord, we should await the decision of the Supreme Court. But I, my lord, will make independent submissions on the desire of the court to hear the state. First is, my lord, and I would end by also saying, my lord, that kindly, my lord, let us all await, my lord, the Supreme Court's decision.
Why haven't you awaited the decision of the Supreme Court?
No, my lord, we had informed the Supreme Court.
Inform the Supreme Court that you will conduct a fresh survey.
Yes.
Did you inform the Supreme Court that you will also issue notifications on the basis,
No, because
basis of the fresh survey?
my lord, please have a look to the order of the Supreme Court, my lord, which is at page 47 of the AO of the commission.
Yes.
AO of the commission.
Yes.
Only one.
Forty-seven, Mr. Dotto.
Yes, my lord. It starts at page 45.
Effectively 47.
47. But here, my lord, the petitioner was the state. Mr. Sibbal Lanet, senior counsel appearing for the petitioners, submits that the West Bengal Commission for Backward Classes is undertaking an exercise of examining the issue afresh that will likely to take further 3 weeks' time, list the matter in July on a non-miscellaneous day. Needness to state that the said exercise will be without prejudice, etc. Therefore, the entire exercise, my lord, what is required to be done post
cancellation of those lists. My lord, we had informed the Supreme Court, and therefore, my lord, the matter proceeded. And my lord, the Supreme Court felt that, or my lord, permitted us to, my lord, continue with the exercise. Of course, my lord, without keeping, my lord, the matter intact. Well, without, yes, yes. Now it was between the same parties. Therefore, my lord, I personally feel, subject to your lordship's consideration, that whether the procedure which has been adopted by us is faulty or not may not be gone into at this stage, subject to, my lord, whatever the directions are passed by the Honorable Supreme Court. But I am, of course, my lord, ready to, my lord, address your lordship on the issues that your lordships want me to address this court.
So, Mr. Dotto, you don't take further steps. We will await the decision. No problem.
But now, my lord, why, my lord, according to the petitioners, there is an electrifying speed at which I am proceeding. This is what they see.
No, you yourself said just
Because,
now
yes,
that the Supreme Court is in session of the entire issue.
the
You have
entire
taken-
exercise. Well, we have said the entire exercise.
Very
The
good. So you
Supreme
also
Court was not told that we will do this and no further.
No, you have read out the order.
Yes.
Where you have told the Supreme Court that the Commission for Backward Classes is undertaking an exercise for examining.
Right.
The exercise, whatever has been undertaken, will either be tested by the Supreme Court or by us.
Yes.
Now, based on this, you did not tell the Supreme Court that you were going to issue notifications on that basis.
No, there are two ways of looking at it. One is, my lord, the Supreme Court may take umbrage of whatever we are doing today on the lines as your lordships are my lord, thinking aloud.
But by that time, third-party rights will be
Yes.
created.
Now, my lord, what is happening is, your third-party rights are being affected by way of these petitions without the third parties being brought on record, number one. And number two is, my learned friends have not told the court the cause of which class are they espousing over here. Whose cause are they espousing? 4 or 5%? Miller, the allegation is that I am intending to favor somebody. Very well. Very well. Take it as correct for the time being. But which class are they representing? And which is that class which cannot come to this court because of poverty XYZ, disability? But please look into the definition of our rules of public interest. Milord,
That we have dealt with in our...
yes, now, yes, today, my lord, I can understand, my lord, in that proceeding, my lord, that question was not gone into. But today, my lord, I think, otherwise it becomes a personal interest litigation, publicity interest litigation. Your lordships have held that. Who is this Amol Chandra Das?
That the Supreme Court will decide. Mr.
No,
Dotto.
in this proceeding, because today, I would very respectfully submit, my lord, a public interest cannot be a personal cause for one person to keep on filing litigations at every stages. Please consider this, my lord, also. And very, very importantly, when, my lord, the exercise was undertaken by the commission, and your lordships were pleased to also ensure that people who want to object can object and go for and participate in the hearings. And that is why, my lord, in the contempt jurisdiction, your lordships were pleased to, my lord, pass orders balancing the rights of all the parties so that advertisements are made known to the persons. Whoever wanted to object can go and object. Now, these people, they don't go and object, and my lord, all, my lord, activities are in court, all acrobatics in court. Now, please look into, my lord, what is the definition of public interest?
That was a bit harsh, Mr. Dotto.
He says,
Mr. Doctor, there is a problem in the sense that this issue of maintainability can't be re-agitated before us. You can agitate that.
Well, this is a new petition, new cause of action.
Petition.
Yes, yes, yes.
Now on the same lines as the earlier one, and we have in substance decided maintainability. Because it was argued in extensio by you and
No,
replied to
please look into the last line of your Lordship's order of 6th of May.
Yes.
Para 18.
Please have a look to that at page 43 of.
Yes, please.
I'll just read for it.
Please.
The maintainability of the writ petitions is kept open on all counts.
Right.
Right. Therefore, now kindly look into our rules. But he has to come and say that X is the community who cannot come to court. I am a benevolent, magnanimous person. Therefore, I take up their cause, I espouse their cause and coming before the court. Because my rules are required, or this court's rule, as your Lordships know, Miller, these rules were framed under orders of the Supreme Court. Because the Supreme Court felt that each and every High Court, they were making their own way
Mr.
of
Dutta,
approach.
we need not go into that question at this stage. We have consciously kept the point open. We are asking you that whether you will stay your hands till the Supreme Court decision or you want a finding in return.
Millard, Millard, I have got.
We are also asking you
Yes.
because as you yesterday also you submitted that don't interfere in this because Supreme Court is in CC.
Yes.
By the order of 6th May itself, a procedure was prescribed. Mr. Mojumdar told us what steps they have taken.
Right.
But the final decision is yet to be taken. In the midst thereof, the executive instructions have come. So today you don't give effect to those instructions till the Supreme Court decides. Finished.
Millard, the difficulty are manifold. Number one is, Millard, how do I carry out the admission process?
Take the 66 classes who are there.
Millard, tomorrow, please consider tomorrow, Millard, after say the admissions are over in the next month, take an example. Millard, your Lordships validates our action. Then the persons for, the classes of.
That my brother has told yesterday. That
There is a chance.
Special recruitment drives, special admission drives are done on a regular basis in this country.
And where are the
That is why, Millard, your Lordships were pleased to, Millard, observe in the previous order that those who have got the benefit, they should not be or disturbed, or Millard, the benefits should
That's
not be.
right.
Yes.
Now they have
Therefore-
got this benefit for 15 years. We would like to ask the commission as to why, what benefit, what were the parameters set, especially what benefit, how has their life improved in the past 15 years? In the context of Section 10 of the 93 Act, where you are supposed to review it every 10 years or every period, which has never been done, unfortunately, we assume that this OBC benefit conferred on these classes, good, bad, indifferent, struck down by us, must have benefited them in one form or the other.
Yes,
That
somewhere got-
aspect has, whether that has been considered or factored in by the commission, we'll have to look into that. Now, the commission will answer it. We will.
Right.
Now, insofar as your first argument is concerned, with regard to the rules of this court on PILs, we have ourselves in our order dealt with that and have recommended amendment of the rules based on a decision of the Supreme Court.
Right.
Because our definition was inappropriate in the light of the observations the Supreme Court made in that case. That is one side of it. We want to only ask you today, not the commission. Today we want to ask you, when we have specifically told, ordered and mandated in a judgment that your actions of a parallel power being conferred on the state executive and the legislature at the same time is unsustainable in law, and we have said that the expression state must be read as the state in exercise of legislative function. How could you have given effect to these recommendations
But I like
by
to- right,
executive
right.
order
Right.
under the 93 Act, that too, throwing the 2012 Act completely to sea without having repealed it? This is what is bothering us.
Very well, very well.
Unless you explain this,
No, I have
this is
no.
all that we want to know, Mr. Dotto, for today's
proceedings.
Milord, may I say this, Milord? I have answers to all the queries of the court. I am going to demonstrate that also.
Just
But-
demonstrate
yes.
this for the purpose, because otherwise, ex facie, what appears to us is the 4 or 5 notifications that you have issued is in direct violation of our judgment.
No, 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 no. Milord, we'll do that. We'll do. Milord, kindly, Milord, do not carry the impression that we do not have materials or actions to justify the steps that we have taken. But Milord, a point of law which is available before me, Milord, 2 points, Milord, which I should take at the threshold. That is what, Milord, I'm taking. Number one
Fair
is
enough. You argue
yes,
that later.
number
But
one is
kindly
that
answer
yes,
this question.
yes. And number two,
Towards the 2012 Act,
yes. Now, Milord,
without following the legislative process,
right? Whether
we,
Milord, I have
we
yes.
needn't explain to you
Right.
what a legislative process is. It is defined under, even most recently in 2025,
Right.
the Supreme Court has defined legislative process.
Right.
Reiterated it. In fact, in the case of Rajesh Singh or something, was the Bihar State Assembly. Now, legislative process means introduction of a bill, discussion, debate, then a decision. Then legislative decision has been separately defined.
No, no.
We have stated
Yes.
that in
Milord,
our
I will elaborate on that. I will. Yes, I will elaborate. First, Milord,
Milord, excuse me, Milord, 1 second. This is not only legislative process. Whatever the observation is falling from my Lord Justice Mantha, this is not only legislative process. Legislative process has 2 or 3 different steps, different classes. One of that is a enactment of the statute. Another is a submission of the report. Another third is if a committee report is placed before the Parliament or the Assembly. Your Lordship is saying the legislative proceeding only when the statute is engrafted. My Lord, that is not sorry, my Lord, with great respect to your Lordship, my Lord, that is not correct in our parliamentary democratic system. Rules of procedures, if you go through it, or either of the Parliament, the Assembly, completely the thing is different. Legislative procedure is something different. It is not, my Lord, maybe citing one judgment, but there are these discussions from the main parliamentary laws. This is not for that. But 25 years in the parliamentary democracy, I have never heard that only the statute, when it will be legislated, that is the legislative proceeding.
We are not making a general observation of what the Parliament or the legislative does. We are saying in the context of these executive orders.
This is not an executive order. Unfortunately, your lordships have taken it as an executive order. These are all are bad. Kindly hear us. Then your lordships makes your lordships comment and observation. Don't please kindly excuse me. Don't jump upon on a conclusion from the very beginning. That will be my request to your lordships.
Very well.
But it is up to your lordships.
Appreciate the language that is used.
Milord, your Lordships may kindly take, Milord, your Lordship's judgment.
What language I have used?
Right. Please carry on.
It's, Milord, the judgment, Milord, the relevant portion or the direct operative portion, kindly take, Milord, page 212 of the affidavit of the commission, which is internal page 188 of my Lord's judgment.
236, Your Lordship.
236, I'm sorry. Well, it's at 236, Milord. Page number match করছে না কেন?
Volume 2.
আপনি writ petition section. এখান থেকে দেখাবার আছে।
Oh, no.
So this is marked, you show this. I'll give the
Yes, please.
The directions portion. Well, the opinion and advice of the commission is ordinarily binding on the state legislature under section 9 and 11 of the Act of 1993. This portion I will rely because commission has made a recommendation. So your lordships have clarified that it is ordinarily binding unless something exceptional is there. Irrespective of whether a request.
Volume 2, Volume 2.
Volume 1.
No, মোটা শোটা আছে দেখো
আমি
ভলিউম 2
তো
দেখো এখানেই আছে
পিটিশন আচ্ছা
Opposition of
from
the
the petition
commission.
কারণ এটা আগে আমি দাগ মেরে রেখেছি
Yes.
Well, internal page 188 এটা কত বলি 286 236 is the running page. Directions, the opinion and advice of the Commission is ordinarily binding on the state legislature under section 9 and 11 of the Act of 93, irrespective of whether a request to look into the over-inclusion or under-inclusion is made by citizens or a body or the state. B, the expression government of West Bengal and the government in section 2F of the Act of 2012 is read down to mean the state of West Bengal and in discharge of its legislative functions having due regard to the reports of the Commission under the Act of 93. Pausing here for a moment, I'll address your Lordship Miller also on this aspect, that what is the expanse of legislative functions? Whether, Millard, it is only confined to passing of bill and passing of acts or not. Whether, Millard, law would include something what is defined under Article 13 of the Constitution. Third part is, Millard, subordinate legislation or delegated legislation. And fourth is, which we are concerned with in this matter, is when something is laid before either the houses of the parliament or, Millard, before the state assembly, to what extent that is also a legislative function. But I elaborate on that, Millard. I'll depend on, Millard, rely upon the directions of this court. Then, Millard, C. The second part of section 2H of the Act of 2012, which reads as and includes such classes as the state government may by notification in the official gazette specify from time to time, emphasis applied, is struck down. But we need not be bothered with that for the time being. Section 16 of the 2012 Act is struck down since it empowers the state executive to amend any schedule of the Act of 2012, including Schedule 1. Consequently, the 37 classes included in the exercise of section 16 of the section 16 by the state executive are struck down from Schedule 1 of Act of 2012. Section 5A of the Act of 2012, which distributes the percentage of reservation in 10% and 7% to the subclassified classes, is struck down. Consequently, the subclassified classes listed in the two categories, namely OBC A and OBC B, are struck down from the Schedule 1 of the Act of 2012. The proviso to Section 5A of the Act of 2012 is read down contextually to read the expression state government to mean the state of West Bengal in exercise of its legislative functions, having due regard to the reports of the Commission constituted under the Act of 1993. The executive orders dated so and so, issued by the government of West Bengal department, classifying 143 classes, are struck down. The executive orders classifying 66 classes prior to 2010 are not interfered with, since those were not under challenge. Then the executive orders classifying 42 classes, inter alia classifying 35 for the purpose of reservation under 16(4) are quashed with prospective effect in view of the illegality of such reports, so and so. The backward class welfare department of the state, in exercise of powers under section 11 of the 93 Act, shall in consultation with the Commission place a report before the legislature with recommendations for inclusion of new classes or for exclusion of the remaining classes in the state list of OBCs. Pausing here for a moment, period. I will dilate elaborately on this J, and try to justify my stand that it is not only in accordance with your Lordship's direction, but it is also following the legislative procedure and the rules of procedure, which is framed under Article 208 of the Constitution.
Yes.
Milord, your lordships were very careful enough to use this phrase, place a report before the legislature. Therefore, Milord, when the directions of the court is, Milord, I would be very respectfully submitting, Milord. I'll elaborate on that. Just, Milord, indicating, Milord, my line of argument is that, Milord, legislative business may include passing of a law in the normal procedure, namely placing a bill, debate, having a debate on it, then, Milord, the bill gets passed, then, Milord, it goes before the governor for assent. Governor may give the assent or may reserve it, Milord, for the president. And whichever way, Milord, once it gets the assent, either of the governor or of the president, then it becomes a law. This is one procedure. The other procedure is, in various statutes, your lordship finds that under such and such provision, the state or the central or XYZ, they can make the subordinate legislature rule, notification, or regulation, etc. There again, your lordship will find difference. Some statute require that it has to be laid before the House of the either of the House of the Parliament or before the state legislation. Some rule do not require. In that case, Milord, there is another two different procedure. This is again, Milord, a legislative action which we call a subordinate legislation or a
Mr. Dotto, it will be open to you to argue this in Supreme Court. You have not obtained stay of our judgment.
Milord, today, Milord,
we are asking that you file your you exchange your pleadings. We will dispose of the writ petition. You are not allowing us to.
Milord, I have.
Now you are making an elaborate submission, interpreting the directions which you have given, which unfortunately has not been.
No, Milord, I am not interpreting. Kindly do not take me
Mr.
amiss,
Dotto,
Milord.
we have heard you for the end. Yesterday, we heard from 2 p.m. to 4 p.m. this matter. We are at an interim stage.
Yes.
We requested you that stay your hands either till the Supreme Court is there. Supreme Court hears the matter. You also said that you should await the decision of the Supreme Court. We left it open for you. Now, Mr. Dotto, if the entire Pandora's box is reopened and it is
At whose instance? Am I not entitled to question this?
We take your point.
Yes.
Maintainability issue we have decided, Mr. Dotto.
Milord, not in this proceeding.
Very good. We have kept it open.
Your lordship has kept it. Therefore, my lord, without deciding the maintainability,
then we couldn't have passed that order on 6th of May.
Could I say this?
Madam, will you please take your seat and don't nod your head constantly when the Advocate General is submitting? Please take your seat, madam. So, Mr. Dotto, we put a simple question to you. Now, if you say that you will elaborate on this and we have to hear...
But I have been invited by the court to elaborate on this.
We have heard you, Mr. Dotto. Allow us to pass.
But I have submissions to make. But that will have a great effect, Milord. It will have a deep effect, Milord. Please consider it. But it's not that, Milord, only for the sake of fighting, Milord, I am doing this. But, Milord, if I have a point of...
No, Mr. Dotto, why should today Supreme Court has not stayed our judgment?
Right.
This argument which you are advancing may be a very good ground for setting aside our judgment.
Very well.
Supreme Court is in session. Supreme Court will hear it in the month of July.
Yes.
So instead of making that elaborate submission before us,
yes,
you can argue because it is your case that await the decision of the Supreme Court. We are not asking you to do anything. We are asking you that has not been the 66 classes we have not disturbed, that we have repeated in our earlier orders also, that we have not disturbed you. But Mr. Dotto, when we have passed a judgment which has not been interfered, can you sit and say that no, this legislative action is this, you are wrong in your interpretation, you are wrong, you are erroneous. These are
no, I have not.
We cannot accept this argument.
Milord, I have been misunderstood. I can only say, Milord, if this is the option.
The higher forum is there, you pass.
Milord, I am here to, Milord,
We have heard enough.
No, I have not.
Kindly allow me, Madam, kindly allow.
No,
kindly allow me to speak,
No,
Milord.
I am extremely sorry to say, Milord, kindly do not stop me.
We are not stopping
Yes,
you.
yes.
We are
Milord,
asking.
Milord, I have not yet started my argument. If the court
Yesterday
says
you started, Mr. Dotto.
no, it's a Milord, I have not started my argument.
You only said that keep it today, tomorrow,
Yes.
tomorrow. At
Milord, please consider one thing, Milord. Please consider one thing. If I have a what is the desire of the court? Yesterday, the court desired that I should demonstrate before the court that I have followed your lordship's order in toto. Kindly permit me to do that. I am not interpreting my lord's order. Yes. But, my lord, please consider at the same time one thing, because since your lordships are minded to pass an interim order, if I have a point of maintainability, my lord, please consider the point of maintainability.
We are not minded to. Please do not prejudge the issue. We are not minded to pass an interim order. We have requested you that in the fact situation, when you also say that Supreme Court is ceasing, all right, I shall not take any further steps till the Supreme Court. We are not minded to pass an interim order. We have put a suggestion. It is up to you to accept or not to accept.
Very well, my lord. We have prepared a short notes. Please have a look to that. কিসের এটা? Or, my lord, before placing the note, if I may, my lord, place before your lordships, my lord, the proceedings before the legislature. I think, my lord, that would be a better option. Copy there?
On clause J. On clause J.
Yes, on clause J. But this is a convenience compilation, my lord, in respect of whatever has happened in the legislature.
Petitioner. Give us a copy.
Yes.
My lord, page 2 onwards, my lord, are the notifications. But I skip them over for the time being. Then page 17 is the interim report of the commission for the period 1st April 2025 to 5th of June 2025. Thereafter, my lord, kindly take me to page number 66.
of?
My lord, this compilation that I've handed up.
Oh.
But at the top of that page, your lordship would, page number, your lordships have got, yes. But at the top of that page, after assembly and all that, the date is June 9, 2025. My lords, I found that.
Yes.
Now, my lord, please take, my lord, page number 68, which is the third page. The reports to be laid in the middle of that page. The following reports will be laid before the House on 10th of June. One is annual report of the West Bengal Commission for Backward Classes for the financial year so and so. Two is interim report. We are concerned about this. Interim report of the West Bengal Commission for Backward Classes for the period so and so, which is at page 17. Then after that, copies of the reports will be made available to the members from the publication counter. After those are laid, members are requested to collect their copies accordingly. I am reading page number 68.
Yes, copies of the said reports will be made available.
Right. Members are requested to collect. Then your lordships may kindly come to, my lord, page number 70. Please come to page number 70.
Yes.
List of business. This is on 10th of June 2025. Bottom of that page, the last two government business, then laying of reports and accounts. There's a heading laying of reports and accounts.
Yes.
Then annual report of so-and-so for the financial year so-and-so. Then Sri Bulu Chik Baraik, he is the minister in charge, to lay the annual report for the commission for the financial year 2024-2025. Then please take me note, page number 71. No, sorry. Yes.
Number 5.
Please take me note, page number 75.
71.
I'm sorry, 71.
Number 5.
But there's a Roman 5 just above that.
Yes.
The interim report of the West Bengal Commission for Backward Classes for the period so-and-so to so-and-so. Then kindly your lordships may take page number
70.
What the Then kindly take me lord brief note of proceedings of the House at page 73. This is the day, Milord, on which, Milord, it was discussed over there. Milord, the relevant portion is at page 75. Yes. Laying of reports and accounts. A is annual report of the West Bengal Commission of Backward Classes for the financial year so-and-so, along with memorandum of action taken on the advice of the West Bengal Commission for Backward Classes laid. Interim report of the West Bengal Commission of so-and-so for the period so-and-so, along with the memorandum of action taken on the advice of the Commission of Backward Classes laid. So laying is done. Now what happens? Please take page number 76.
76.
Statement under Rule 346. The Chief Minister made a statement in respect of the annual report of the West Bengal Commission of Backward Classes for the financial year so-and-so, along with memorandum of action taken on the advice of the West Bengal Commission for Backward Classes and the interim report of the West Bengal Commission for Backward Classes for the period from so-and-so, along with memorandum of action taken on the advice of the Commission so-and-so, laid on table on this day. Then kindly take me note the page number 78, skipping over 77.
Minister.
Now this is, my lord, the proceedings are going on after it is laid. Now it's on the table. 78 says, laying of report and accounts, the annual report of the commission for so-and-so for the financial year so-and-so, along with the memorandum of action taken on the advice of the commission, etc. Sri Bulu Chik Barai, Honorable Speaker, sir, I beg to lay the annual report for the commission for the year so-and-so, etc., along with the memorandum so-and-so. Here, take printed copy of the annual report marked A attached herewith. The interim report of the commission for so-and-so, along with so-and-so of the advice for so-and-so. Then Bulu Chik Barik, Honorable Speaker, sir, I beg to lay the interim report for the so-and-so for the period so-and-so, along with the memorandum of so-and-so. Take here printed copy. Now come, my lord, page number 79. Now this is the discussion. But this is an extract made of the relevant portion. Yes. But it would be later on revised. Vidhan Sabha, etc. Mr. Speaker, honorable members, annual report for the commission for backward classes for the financial year, etc., etc., interim report, etc., along with action taken on the advice of the commission. These two reports have been laid. Honorable Chief Minister is here. She wants to highlight something in respect of the reports that have been tabled today before this House. Then Srimati Mamata Banerjee, মাননীয় অধ্যক্ষ মহোদয়, আমি আপনাকে কৃতজ্ঞতা জানাচ্ছি যে একটা ক্লিয়ার ব্যাপারে আপনি আমাকে অ্যালাউ করেছেন আমার সাবমিশন প্লেস করার জন্য। আমার এটা প্রয়োজন হতো না যদি এটা নিয়ে নানা রকম ভ্রান্তিমূলক অপপ্রচার করে মানুষকে বিভ্রান্ত করার চেষ্টা করা না হতো। কে করেছে না করেছে আমি এসব বিতর্কে যেতে চাই না। সব ভালো যা শেষ ভালো, এক্সেট্রা। ওবিসি মানে হচ্ছে আদার ব্যাকওয়ার্ড ক্লাস। হাইকোর্টের ডিভিশন বেঞ্চ আমাদের একটি অর্ডার দেন 22শে মে 2024। আমি শুধু আপনাদের জানানোর জন্য হাউসকে অবগত করার প্রয়োজন আছে, এটা খুবই সিরিয়াস ম্যাটার, এক্সেট্রা। মিলর্ড, the other things, Milord, are said. Then, Milord, after, but at the end of the Honorable Chief Minister's speech at page 80, the fourth line at page 80, With your kind permission, may I lay it on table of the house? Yes. Let it be laid on the table of the house. Then when other things are discussed, these are all Millard, yes, on Millard OBC, whatever it is. Then please take Millard, page number 83. It continues. Page number 83 at the bottom, kindly take Millard. Yes. Where from 12:30 to 1:50 Millard, these discussions take, and then but towards the bottom Millard of page 83 Millard in English, at this stage the honorable leader of opposition rose to speak. Mr. Speaker, ধন্যবাদ মাননীয় মুখ্যমন্ত্রীকে, please, I have seen the order of the Honorable High Court, and according to the spirit of the order of the High Court, it has been properly laid, so I extend my thanks to the Honorable Chief Minister for making a statement. So, Millard, the leader of the opposition, Millard, also make his submissions, saying that whatever it is, Millard, whether it is in terms of the High Court's order or not, that is something different. But Millard, এটা তো দিল্লি তো
এটা হয়েছে 150 150 শেষ হয়েছে, ক্লোজ হয়ে গেছে। পরের পাতায় আছে না?
Yes, please.
Yes. Therefore, Millard, the concern of the court, but again, kindly don't take me amiss that I'm trying to interpret your lordship's order. But Millard, your lordships wanted to ensure, if I've understood correctly, that Millard, it passes through the people of the house. That is why, Millard, the direction was that lay before the assembly. It has been laid before the assembly, had a discussion. The leader of the opposition also accepts it. But I am not on whether it is in terms of the High Court's order or not. Accepts, and Millard refrains from making other submissions and says it has been properly laid. Now, once it is properly laid, then what is the situation? Yes. Millard, please have a look to my one judgment, Millard. I don't think that we need
86. No, what is the step after that, Mr. Dotto?
Yes. But thereafter, Millard, we have gazetted it where, for example, your lordship may take, Millard, page number 86. Take as an example, Millard. Page number 86.
Yes.
This is 10th of June. Yes. Now, please take, Millard, page number 87. What is the power exercised? Now, therefore, in consideration of the recommendation of the Commission and in the public interest and in pursuance of the provisions of Clause C of Section 2 and Subsection 1 of Section 9 and Subsection 1 of Section 11 of the said Act, means it's in the 93 Act, and in continuation of notification dated, etc., the Governor is pleased hereby to subcategorize so and so, so and so, so and so.
66 to 64 হয়ে গেছে 64 plus is 66.
So this is done under which act?
Yes. Now please take me 93 Act. But after it passes through the legislation or the legislature, then, Millard, I have to exercise my power, Millard, under the relevant statutory provision. Please address 93 Act. Just
No, is that not reflected in this order?
yes, it's there, Millard, the penultimate paragraph, Millard, the last part of the recital at page 87, for example. Or, Millard, may I read it, Millard, from the top, Millard?
Please do.
Yes. Please take me at page number 86. Number, etc. Whereas the backward classes have been defined in Clause A of Section 2 of the Commission Act 93 for the so and so to mean such backward class of citizens other than the scheduled caste, scheduled tribe as may be specified by the state government in the list. Whereas the list have been defined under Clause 2, etc. Then whereas the state commission was set up under Section 3 for identification. Then, and whereas in terms of Section 9 of the Act, the Commission considers inclusion, over-inclusion and under-inclusion of any other backward class and tenders such advice to the state government as it deems appropriate, and such advice of the Commission being ordinarily binding upon the state government. And whereas on recommendation of the Commission and in public interest, the Government of West Bengal published notification subcategorizing so and so, which will mean etc. etc. And whereas the Commission has decided to conduct a benchmark survey through the Bureau of Applied Economics and Statistics and Cultural Research Institute covering so and so classes to determine their degree of backwardness, and whereas pursuant to the receipt of the report of the survey of so and so, the Commission has, based on detailed surveys and comprehensive consideration of all relevant materials and data, formed a reasoned opinion and recommended to the state for subcategorization of 64 classes. Now, therefore, in consideration of the recommendation of the Commission and in public interest, and in pursuance of sections 2C, 9(1) and 11(1) of the said Act, that is 93 Act, so and so, as clause category A and category B. Now, Miller, please take me at the statute. I'll come back to a decision of the.
It was done. The legislative process has been
right.
We are satisfied with that.
Very well.
The notifications are issued under the 93 Act.
Yes. Please, now, Miller, I'll demonstrate from both the acts, 93 as well as the 2012 Act, which survives after your, I mean, the truncated 2012 Act.
So notifications were issued before it was laid before the House.
No.
27th May.
These,
it was laid before the House in June 25.
Yes, these are drafts. Yes. But these are drafts, my lord, which was finally, as your lordships know, my lord, unless it is gazetted, it doesn't take effect. I don't think I need to dilate on that.
Yes, that is okay. But this is not a, page 86 is not a gazetted notification.
Page 86, yes.
Which is showing. Yeah.
Yes.
It's a gazetted notification.
Yes.
Gazetted on
27, yes, 27th May is gazetted on 10th of June. Therefore, it takes effect on 10th of June. Yes. Yes. Just below the state emblem. Now, my lord, your lordship may kindly take, my lord, the 1993 Act. Yeah. Okay. I see. And my lord, the last document in the convenience compilation is 11 June, my lord, when all other departments were informed about it.
But Mr. Dotto, this is not a notification under the 12 Act.
93 Act.
90. So we said in our judgment, 12 Act, you recast the schedule. You would be at liberty to do so. Kindly come to clause H of our direction.
Yes. Yes. Well, there are two things. One is,
correct us if I am wrong.
Yes,
that this schedule inclusion will be under the 2012 Act by a legislative process.
Right.
What you have shown us all are in respect of the 93 Act.
Right.
So no class has yet been incorporated on the basis of this under the 2012 Schedule 1. In the absence thereof, Mr. Dotto, how it can be proceeded?
Millard, may I, Millard, place both the acts, Millard? I'll definitely, Millard, make things clear. Millard, kindly have a look to the 93 Act first.
You have given us a copy? No.
Yes. Millard, we have prepared a short note, Millard, which I have handed up just before handing up the
Yes. This one.
Yes. But I skip over, Millard, para 1, para 2. Now please take para 3.
Yes, please.
Since the power of the state executive was being taken away through an interpretation of the 2012 Act, the Honorable Court evolved a mechanism for classification of OBC with reference to Section 11 of the 93 Act. In this regard, Direction J is quoted. Therefore, every case of inclusion in the OBC list would refer to the provisions of Section 11 of the 93 Act with obvious modifications, thereby by implication. In this regard, a very limited power was granted to the state government to submit a report to the state legislature based on the commission's finding for the inclusion of class in the OBC list. No other power was conferred on the state government. However, legislature cannot legislate on its own. Therefore, the judgment dated so and so has a specific direction by interpreting Section 11 of the Act, 93 Act, such that the inclusion or exclusion of OBC would take place by laying a report before the legislature with the recommendation of the commission and no other means as was provided. Under such circumstances, the only manner in which the state legislature can make a decision for inclusion exclusion would be for it to deal with such report in terms of the rules of procedure of the state assembly. Rule 319 of the rules of procedure provides for proposal on such matters and discussion thereof. Rule 319 is quoted. A motion that the policy or situation or statement or any other matter to be taken into consideration shall not be put to the vote of the House, but the House will proceed to discuss such matter immediately after the mover has concluded his speech, and no further question shall be put at the conclusion of the debate at the appointed hour, unless, this unless part is important, a speaker moves a substantive motion in appropriate terms to be approved by the speaker, and the vote of the House shall be taken on such motion. Here, your lordships have found the leader of the opposition was satisfied. Therefore, my lord, the question of no further.
The leader of opposition or anybody, nobody has objected to the, has raised any motion.
Any other member could have done so. Thus, no voting is to be conducted on such action, laying of report, unless a member moves a substantive motion in appropriate terms to be approved by the speaker. In this case, no such motion was moved, and therefore it would be deemed that with the conclusion of the discussion and no objection being made to such report, the same stood approved in so and so. Then, my lord, we have relied upon a judgment. I don't think, my lord, that is very required, but still I'll just read it. Once a report is forwarded to the legislature, the matter exclusively enters the domain of the legislative function, see so and so, and unless any contrary decision is adopted by the legislature, the same necessarily is to be treated as an approval. Once the matter is placed before the legislative assembly, it falls within the arena of the legislators, who eventually are the representatives of the people. No. If my lords require, my lord, I can place that judgment. I don't think that, or just
It's not necessary.
no.
That's all right.
Well,
It's a legislative passed in the assembly.
Well, I will not.
Thereafter, what is the step?
Yes. It is only after the approval of the assembly of the report prepared on the basis of the commission's finding was the approval of the assembly given effect to by the state through publication of the notification, which are statutory orders in the official gazette. This is so because the West Bengal Legislative Assembly by itself cannot make any publication under any provision of law. The same necessarily has to be done by the state government. Then, my lord, the presumption of constitutionality is para 12, then para 13 according to us. Therefore, para 361 of the judgment has been complied with in letter and spirit. It must be clarified at this juncture that this honorable court had reserved the process of inclusion of OBC through list under the 93 Act as opposed to Schedule 1 of the 2012 Act, since Section 16 of the 2012 has been struck down. This court has done so consciously. Yes. In para 361G, I'll elaborate this para 14 for your lordship's consideration. This honorable court has done so consciously in para 361G of the judgment, keeping in mind that placing of a report before the legislature will be the legislative function for this purpose. Therefore, the entire process of inclusion has been carried out by the state exclusively in exercise of its legislative function through the act of laying the report before the WBLA. In this regard, 361B is so and so. Then, my lord, para 16, my lord, is the answer to my lord's subsequent query that what is
14,
to be done.
Mr. Dotto, we are not fully satisfied with. 14, para 14, argument in para 14.
Well, I'll elaborate.
That is
Yes,
why you chose the 93 Act instead of
I'll elaborate.
25
Definitely.
Act.
I owe an obligation. I owe an obligation to my lord satisfy
Please.
your lordship on that. Then Millard, para 361B, Millard, we have quoted in para 15. Then it is not the case of inclusion through any executive orders divorce any statute, but by exercising statutory power on the legislative side, and thus statutory orders in terms of 93 Act, 2012 Act as interpreted and read down by the 24 judgment. In light of above, no prima facie case for passing of interim order is made up. In any event, the Supreme Court, well, that is Millard, my submission. Millard, since Millard, your lordships are satisfied on the legislative aspect, but I don't go into the those provisions of the Constitution which says that legislative functions
not
business should
necessary.
not come before
Not
the court.
necessary.
Not necessary. Now, Millard, please take why I have exercised powers under the 93 Act and not under 2012 Act. দুটো দিয়ে জজ সাহেবদের আগে 93টা দে। Please take me on 93 Act first.
Yeah.
Look, Section 9, Millard, your lordships have already considered that this is the Commission's power, Millard, for inclusion, over-inclusion, etc., etc. Then Section 10, I skip over. The next chapter, I skip over. No, sorry. Please give me a moment, Millard. Yes, please take, Millard. I'm so sorry, Millard. Please take Section 2, subsection C.
Yes, lists.
Lists. Lists mean list prepared by the government of West Bengal from time to time for the purposes of making provision for the reservation of appointments or posts in favor of backward classes of citizens which, in the opinion of that government, are not adequately represented in the services under the government of West Bengal and any local or other authority within the territory of West Bengal or under the control of so-and-so. Then, Millard, the commission's functions start. Then, please, Millard, your lordships have gone through it a number of times. Please take Section 9 once more. Millard, 93 Act contemplates list, whereas 2012 Act contemplates schedule.
Give us the 2012 Act copy.
আচ্ছা No, আমার দাগ মারা আছে। Please take, Millard, Section 2F of 2012 first. But this has been read down by the court.
Yes.
List means list prepared by the government of West Bengal from time to time for the purpose of making provision for the reservation of appointment or post in favor of backward classes of citizens which, in the opinion of the government, are not adequately represented in the services under the government of West Bengal or any local or other authority within the territory of the state of West Bengal or under the control of the government of West Bengal. This, Millard, your lordships were pleased to read down as the state government of West Bengal means the state in its legislative field or legislative function. This is what, Millard, your lordships have read it down. Therefore, a list is prepared by the government in the exercise of its legislative functions. This is, Millard, what we understood, subject to your lordship's correction. Then, Millard, I don't trouble your lordships with the other. No, পাঁচটা দেখাতে হবে। Yes. 5, Section 5, not there. Yes. 5A is not there. Yes, I stand corrected. Yes.
It's not there.
A gone, the proviso to A survives, B survives. Then your lordships may kindly take me, Lord, directly to 16.
16.
1-6.
Yes,
This has been struck down by the court.
that's right.
The state government may, by order published in the official gazette, add to, amend, or alter any schedule.
Right.
This has gone.
Deleted.
Therefore, my lord, we do not have any power today under section 16 to amend, alter, add any schedule. Therefore, we have to fall back, subject to your lordship's correction once again, on 93 Act. Now, please come back to 93.
No. 1 minute, 1 minute. Mr. Dotto, we have struck down the power of the state executive. We've always said state means state legislature. The legislative process has been completed appropriately. Good, in whichever way, that we will hear them prima facie. The declaration, therefore, had to be a decision of the legislators, of in whichever form, under the definition of 2F and bringing in amendment under the 2012 Act, including a schedule under the 2012 Act, not the 93 Act.
May I say this, Milord?
Because dictation sections is struck down since it empowers the state executive.
It should have been under the 2012 Act.
Milord, could I assist your lordship on this? Milord, the purpose of the 2012 Act is to provide for reservation in service. Today we are at a stage, or Milord, what is pending before your lordship for consideration is, Milord, classifying certain classes as OBC or subclassifying them. Therefore, Milord, of the two acts, 93 and 12, please first kindly, if I may, having placed 2012 Act, please, if I may go back to 93 Act, please have a look to 93 Act. Nine one. But list, Milord, I have placed, Milord, definition of list.
Mr. Dotto, you said that there is no schedule remaining in the Act, 2012 Act.
If that section goes, Milord, I do not retain any power to add, alter, etc. to the schedule.
No, subject to the legislative function. Your argument was that section 16 you have struck down. So how can I amend the schedule? That if we have
There are two arguments on that.
Schedule.
Yes.
You have a commission that has given you a report. Commission that has given you recommendations. Commission that has given you subclassification also. You can classify A, B for these reasons. You have tabled that before the legislature. Excellent. In terms of what we have directed, there has been discussion, good, bad, whatever. The legislature has passed it. The obvious next step would have been introduction of amendment to the 2012 Act, which comes in introduction of schedules. That portion has not been done. Instead, you fell back on the 93 Act,
yes, Milord,
which defies logic.
May I say this, with respect, Milord? Reserving my right to justify my action, may I say, Milord, to immediately answer to, or Milord, dispel the doubts from the mind of the court, that whether I should have applied the 93 Act or should I apply the 2012 Act, whichever. Now take a case that, Milord, 2012 Act was required to be adopted or taken recourse to instead of 93. But if the court is satisfied that I have undertaken the exercise as per the directions of the court, number one, that is the legislative part. If the court is satisfied that I have a right to declare them and classify them as OBCA and OBCB, number two, if the court is satisfied that I have a right to provide for reservation for these categories of classes subject to the optimum level of reservation, then at the most, my lord, it is a wrong quoting of provision, nothing more than that. But
wrong
still I will
administration.
justify. So, my lord,
One
yes.
part. We are only prima facie seeing all this. This is subject to hearing the petitioners in the first place. This we are hearing you to ensure as to see whether the judgment has been complied with. We do find, as we have indicated to you, that the matter has been placed before the legislature. There has been no opposition whatsoever.
Right.
There is not a single member who stood up and said that no, I want to move some motion against this or whatever. There was no question of voting. It was passed on.
Yes.
And the next obvious step was to introduce the amendment to the 2012 Act by introducing the schedules, which is the obvious thing to do. The reason why we read down the portions of the Act of 2012 is only because there was no reference to the 93 Act at all. Whereas Indira Sahani mandated that the commission's role cannot be ignored under any circumstances.
Right.
Now, if you remember in course of arguments in the earlier matter, Mr. Dotto,
Yes, sir. Yes,
he
sir.
asked you repeatedly what is the object of the 2012 Act.
Yes.
You had the 93 Act and you had Section 60, Article 16 of the Constitution of India.
Yes.
I believe the same question, I understand, was put by the Supreme Court. Why did you need the 2012 Act? Good. You have chosen the legislative method, which is an appropriate method, so that you inform all sections of society represented in the legislature that yes, these are the classes we are wanting to include. You don't want to do it by executive action. That's why you introduce the 2012 Act, which is very laudable. You've complied with half the procedure. The rest you have abandoned. You've gone back to the 93 Act. This is what defies logic.
But may I say this, Miller? Number one, Miller, the object of the 93 Act and the object of the 2012 Act, in my very humble submission, subject to your Lordship's consideration, but the objects are different. Why? 1993 Act is to set up a commission and to empower the commission to look into the complaints or requests for inclusion, over deletion, etc., etc. And Miller, upon looking into that, what is and once Millard these are decided by the looked into by the commission, but whichever Millard classes are Millard recommended by the commission, Millard, there would be a list, and in that list there would be an inclusion. That is why Millard section 2C of the 93 Act is important on the aspect that your Lordships are presently Millard hearing me on. Please,
Dotto,
yes.
We have seen your note, we have seen your arguments, we have noted your submissions. Can we hear the other side now in reply?
Yes. No, Miller, your Lordships.
Because we have heard you very patiently for
No,
over an hour.
Miller, I am really very grateful, Miller, for the patient hearing that your Lordships have
We
given
will
me.
hear you more. But at least for the purpose of our decision as to whether or not an interim order is warranted, let us hear the other side in reply.
Yes, Millard, only Millard, this one sentence more.
Please.
One sentence more is that, Millard, so long, Millard, I was trying to, Millard, justify my action based on, Millard, what fell from the court yesterday. I had, Millard, two additional points to, Millard, which are in the nature of dema. The two additional points also, Millard, your Lordships may kindly consider.
Sustainability and
Yes.
locus.
Yes. Now, who is this person? Why is he running after this? He must say that I have come here for that person who cannot come before the court. Otherwise, when ordinarily, Millard, ex community will come and say that why I have been not included. Why has
We'll
committee?
consider it.
Yes.
We've noted it.
Yes.
Mr.
The only thing is,
We've considered it. Now let us please hear the petition.
Can I, Milord, kindly give me 5 minutes, Milord, 5 minutes.
Yes, Mr.
Milord, just kindly just 5 or 7 minutes.
Mr. Bandyopadhyay, your point has
Milord,
been
just
noted.
I will be getting clarifying from your lordships, Milord. I will kindly do not mind, just your lordships question query is this. If I have understood properly that you could have made an statutory amendment of 2012 after laying down the report itself. This is exactly, if I have understood correctly. My lord, kindly see. A subordinate legislation, when it's placed, it's part of a statute. In our reading of the judgment, maybe my reading is incorrect. Your lordship's reading would be, there is in your lordship's judgment, this inclusion in the schedule has been struck down. Now, what is the power of state? It cannot be a law, my lord, that 2010 which stood, that will be the only the OBC years after years. It cannot be. Otherwise, my lord, the backward and economically backward classes. Incidentally and unfortunately, 1993 Act itself economically has not been written down. But the OBC concept under the Constitution is otherwise backward and economically backwards. These are the two factors that there. Now, therefore, my lord, kindly appreciate this. Today, an application has come. Ball has been. My lord, we are not criticizing your lordship's judgment at all. Do not take it here. Rather, if we satisfy your lordships on our grounds today, that these are the grounds in accordance with your directions we have taken these steps, and steps are correct. We may not proceed with the appeal itself because we have taken steps in accordance with your lordship's order. We don't have any confrontation with your lordship's judgment. Whatever we have understood from your lordship's order, my lord, kindly do not mind, my lord, just kindly excuse me with your, my lord, with the great respect I am saying, with the respect. But if there is a failure of my understanding, then my lord, there is some grey part in your lordship's judgment. Possibly, my lord, your lordships were not clear there. According to my lord, maybe I am incorrect. Do not mind my lord, just a discussion I am saying. Every steps have been taken to give effect to your order. We don't have now any quarrel with your lordship's judgment. We are accepting it. And if my stand is accepted, we don't need to go. Therefore, kindly see, your lordships in one process is saying section 16 is struck down. If section 16 is struck down, second 2H, second part is struck down. There is no scope to include in the list.
Very well. We have noted the submissions.
Well, this is and second thing is this, Milord. Your lordships are having enough experience on that balance of convenience and inconveniences. My lord, it is whatever in your lordships may say, you go on this, 66. But my lord, I tell your lordships, I am a member of a OBC committee, parliamentary OBC committee. And from 2015, Central Commission has not submitted any report, included any caste. Why? Population has grown up. That has to be taken into consideration. Now, if you even, I will request your lordship, do not pass any interim order. Let us proceed immediately within, say, 10 days, everything will not be done. Process may commence. Your lordship, hear us. If your lordships are satisfied thoroughly, then your lordship will strike it down. Allow us, abide by the result of the applications.
Very well. We've heard you, Mr.
My
Mandapati.
lord, I am so grateful that your lordships have heard it. My lord,
Always.
and never take my lord Justice Mantha anything personal. You know me always. I always very grateful to all of your lordships.
For some time. Yes, petitioners, reply whatever you want to say.
May it please your lordship. Lords, do I have your lordship's leave to make a brief reply submission?
Yes, please.
Lords, if the contention of the state is that the notification of the lists under the 1993 Act is an effective substitute for a legislative measure under 2012, Lords, that would be an untenable position in law under the constitutional law and as a legislative practice. Kindly come to paragraph 214 of your lordship's judgment dated 22/5/2024. It is at page 134 of the affidavit in opposition. In our writ petition, 111, paragraph 214 of your lordship's judgment at page 134.
214.
This is in relation to the reading of section 2F of the 2012 Act. Your lordships have it? 134, sir.
Of the writ petition?
No.
Of the judgment, of the judgment rendered by your lordship on 22/5/2024.
Judgment? Which paragraph?
Paragraph 214.
Yes.
Your lordships quote Ram Javaya Kapoor and hold this. Section 2F inter alia therefore would also enable the state government to make provisions for reservations in service. This is impermissible given the state legislature stands empowered to provide for reservation in services under the state. Hence, 2F calls for interference by this court. In this regard, reference may be had to the decision of the Rai Sahib Ram Javaya Kapoor versus State of Punjab, and your lordships quoted. Permit me to read it. Paragraph 12, in parenthesis. It may not be possible to frame an exhaustive definition of what an executive function means and implies. Ordinarily, the executive power connotes the residue of government functions that remain after legislative and judicial functions are taken away. The Indian Constitution has not indeed recognized the doctrine of separation of powers in its absolute rigidity, but the functions of the different parts or branches of the government have been sufficiently differentiated, and consequently it can very well be said that our Constitution does not contemplate assumption by one organ or part of the state of functions that essentially belong to another. The executive indeed can exercise the powers of departmental or subordinate legislation when such powers are delegated to it by the legislature. It can also, when so empowered, exercise judicial functions in a limited way. The executive government, however, can never go against the provisions of the Constitution or of any law. This is clear from the provisions of Article 154 of the Constitution, but as we have already stated, it does not follow from this that in order to enable the executive to function, there must be a law already in existence, and that the powers of the executive are limited merely to the carrying out of these laws. Then kindly come to paragraph 357 of your lordship's judgment. 356, my lords. At page 211.
Yes.
After the, 356, your lordships have it. After the commencement of this Act of 2012, only the state legislature is empowered to make provisions for reservation in the state services thereunder or under Article 16(4). The state executive, therefore, is no longer permitted under the Act of 1993 or even under 16(4) to make provisions for reservations of OBCs in state services. My lords, it's a settled position of law, which your lordships have acknowledged in paragraphs 214 and have issued a negative injunction against the state on what the state ought to and ought not to if there is a repeat exercise. if the field of legislation is decidedly occupied by a legislative measure. Now, kindly take the 2012 Act, sir. Kindly see the objects of both the enactments which the learned Advocate General, while referring to us as acrobatic, has tried his fair bit at it by himself. But kindly come to the statement, what does the Act seek to provide for? 2012 Act. It is a legislative expression for bringing in the measures under 16(4). An act to provide for the reservations of vacancies. Your Lordships have statement of objects and reasons of Act 39 of 2012.
Yes, please.
Yes. An act to provide for the reservation of vacancies in services and posts for the backward classes of citizens other than the scheduled castes and scheduled tribes. 15(4) and 16(4) are referred to. Now, my lords, 38(1) and 2 are referred to. Kindly come to the last but one sentence before the commencement of section 1. And whereas it is expedient to provide for the reservation of vacancies in services of posts.
Yes.
Lord. So therefore, this legislation of 2012 is a complete code insofar as the state's options to provide for reservations under 16(4), when it arrives at a satisfaction through the medium of the Backward Classes Commission under the 1993 Act that there are SCBCs who are underrepresented in the services of the government. Now, while this is for 16(4), the state of West Bengal has another act for admissions. That is, the 2013 Act.
Sriram, you please respond to the Advocate General's argument and Mr. Bandyopadhyay's argument. The effect that we have struck down the schedule.
Yes.
Thereof, in view the question of application of any provisions thereto had not been in our mind. Otherwise, the direction might have been crafted in any other manner.
Yes. Therefore, my lords, in my respectful submission, what your lordships clearly manifested in the direction, there was no gray area. There was no scope for any misunderstanding of what your lordships intended and held. Read along with 214, 357 and 360. The only course that was available to the state was to reintroduce the schedule on the basis of the lists published, which would be the lists under 2F also of the new act as well. And that would have secured the mandate of legislative approval. My lords, this lexical distinction between the placement and the laying before the house, calling attention, and as to whether they are substitutes for a legislative instrument, my lords, it's too obvious to even mention a rebuttal for it. In my respectful submission, if the legislation is occupying the field and it is not yet repealed, then it is not an effective substitute for the state to make a provision for reservations under the 1993 Act. It will fly in the face of paragraph 357 injunction, where your lordships clearly held it is not open to the state to cause reservations under the 1993 Act also. Kindly see as to whether 1993 Act even provides for a 16(4) measure. Kindly see as to what is the scope and ambit of the functions of the Backward Classes Commission and whether the state is empowered to publish a list there. Kindly see this. My lords, this is a creation post the Indras on a recommendation of an arm's length body. Whether this body is arm's length at all, your lordships had an occasion to deal with in the past. I will have my reservation to say that in the future when your lordships hear it substantively. But kindly see the object of this legislation. How is this a subordinate legislation referable to 1993 Act when the government is not empowered to publish a list under this Act? What is incorporated by reference under 2F as a list is a list if and when published, not under this Act. Kindly see, my lords, 2C. There was no gray area anywhere. Your lordships perfectly understood the law. As of today, there is no stay of the judgment. Kindly see 2C. In order for us to appreciate the submission made by the learned Advocate General and the learned Senior Counsel appearing for the Commission, your Lordships may have to construe the term lists under 2C of the 1993 Act as a list published under this Act. Now, kindly see, my lords, under the provisions of this Act, there is no power under the state for the state government to notify the provision of reservations under the 1993 Act. It can only, the lists, if any, notified either under executive power or any other legislative power, is a list for these purposes. Kindly see 2C. Lists means lists prepared by the government of West Bengal from time to time, not under this Act, for purposes of making provision. Your Lordships have it?
Yes.
For the purposes of making provision. My lords, the notifications issued which are impugned in the present writ petition is not a piece of subordinate legislation under the 1993 Act. It is but a notification issued under Section 9, read with Section 11 and 2C. This is a causation of public information by purposes of a gazette. The Act is not a code for providing for reservations by the government. The Act starts and ends with a fact-finding, giving of recommendations, and for which is ordinarily binding on the government, if your Lordship sees Section 9 and 11, which your Lordships have correctly read.
All right, sir.
The scope of the Act is very limited, my lords. As for the balance of convenience, my lords, your Lordships have repeatedly held that while a provision under 15.4 and 16.4 is a classification implicit in 15.1 and 16.4, any provision for a classification, therefore, if it does not answer the requirement of intelligible differentia and the nexus ought to be achieved, is a departure from 14. And therefore, the balance of convenience is in favor of maintaining the status quo as on the day on which the provision has been introduced, for the reason that if these provisions come into force, and which is, my lords, last evening, after the hearing concluded, I am instructed to state that the state has issued another notification calling upon all the officers of the state to issue caste certificates in accordance with the lists notified now. They are in a tearing hurry to, yes, they have given it last evening. The matter is going on here. They want to provide us a fait accompli, render the writ petitions infructuous, and allow for another generation, another 10 years, my lords, where Article 14 and 15 is sought to be violated at will. When the matter is at large before your Lordships, and your Lordships have posted the matter to today at the request of the other side, to facilitate conclusion, the post haste, my lords, the conduct of the parties, your Lordships have also held, and it is now part of the statutory law under 41 of the Specific Relief Act. I'm only saying an analogous principle is applicable. Your Lordships would kindly see the conduct of the party. I am before you. We have been seeking your Lordship's urgent attention. Notification after notification comes by. No liberty is sought from anywhere. All right, there is no interdiction of the same. But this particular tearing hurry to provide us a fact situation which cannot be interdicted or which can be argued to be a mammoth ramification case for dissuading your Lordships for passing an interim order indicates that the state wants to run away with this measure. Well, in my respectful submission,
all right.
in my respectful submission, therefore, your Lordship, very well.
Like it will be preferred challenging the identity and classification.
Scan number?
Can 2 and can 3, my lord.
Can 2 and 3.
In connection with 111. 7 of 2024. Uh-huh. Mr. What is your name? Uh-huh. Azad.
Please give your name and a slip.
Mr. Learned advocate submits that
Two can applications can 2 and can 3 of 2024.
where are those? Are they in the list?
But they are appearing in the list.
Can 2 applications for addition of parties? Submits that two applications for addition of parties being can 2.
Following
We have said the notification and all consequential steps.
Lord, my lords have been pleased to grant us leave to file opposition to all of us.
Don't worry, sir. On 24th July, your contempt along with your applications will appear. Then if they do not wish to use any opposition to that, we can consider your addition on that date. Since we have passed the writ petition only on 4 matters within the contempt of.
ঠিক আছে কাল সকালে